Good afternoon, everyone. I'd like to convene today's meeting of the Labor and Public Employees Committee. I would ask my co-chair at this time, Senator Kushner, for any remarks.
No, I'm just ready to get started. Thank you all.
Thank you, Senator. I would like at this time to ask Ranking Member Senator Sampson, Representative Weir. Okay. All right, at this time, we will go into item 3 of our agenda, bills for final action. We have 14 bills ready for final action today. I would entertain a motion to J up to the floor. Item 1.
Representative Hughes, so moved.
Second it.
Moved by Representative Hughes, seconded by Representative Wilson. Okay. So the bill, SB 136, enact making changes to the Connecticut Retirement Security Program. This bill makes various changes to the Connecticut Retirement Security Program, a retirement program the Office of the State Comptroller administers to establish Roth individual retirement accounts for eligible private sector employees. Discussion. Senator Sampson.
Good morning, Mr. Chairman. Thank you very much for the recognition. Just looking at this bill, it's a pretty lengthy bill. I think it has 10 sections altogether. And what I originally thought when this came before us was that this was going to be some relatively minor changes to this this program. But the more I look at this bill, the more I realize that it's pretty substantial what's going on here. And I think what I'll do is I just want to go through maybe the sections first and then kind of talk about what we've discovered and how it's going to impact the citizens of our great state. The first section, which amends section 21-416, has to do with the actual amount of the contribution. And it looks like what it's doing is it's changing the contribution that is taken from paychecks from 3% to 5% for participants that are enrolled after July 1st, 2024. The one of the main issues I've always had with this program is that you're talking about creating a state-run retirement program, which I don't really see a need for, since these types of products are available, in the private sector. And in fact, I mean, all this is a mechanism to take funds from people's paychecks and then, get them into some sort of retirement program that is in the private sector already. But to me, that's the issue, which is that, it's frustrating when I see the state government attempting to compete with businesses that actually operate in the private sector. And I also find it frustrating that this particular program can happen for a lot of our Connecticut residents and citizens really without their knowledge. Because even though it's been described as an optional program and you have to physically opt out of it. And there are a lot of people in our state who are already aware that there's money being deducted from their paycheck. They might not be looking too closely at what's being deducted or why. They just assume that this is money that has to come out for government purposes, which I would encourage anyone who is listening to take a harder look at the money that's coming out of your paycheck, period. And that's going to, Social Security and other, federal programs, and then recognizing that now the state is also taking a very active interest in finding ways to glean money that you've earned before you even get to see it by inserting themselves between you and your employer. And that's what this program is. I've opposed it since the beginning based on those grounds, because I think that, first off, I don't think it needs to exist. As I mentioned, you can go out and invest money for your retirement in a multitude of places today. And it's not hard to do. I mean, you can go online in 5 minutes and find some, institution, whether it's TD Ameritrade or Schwab or somebody, who will be glad to help you invest, part of your pay and set up an automatic deduction, or even probably find a way to incorporate it in your paycheck if you want. You don't need the state to do that. And furthermore, you don't need the state to come along and do it without asking you first, which is my great frustration. And, so I'm saying all this because I'm leading up to the fact that that is the root problem that I have with this legislation. But what's happening in this bill today is an expansion of that program to make that contribution, which I think is the wrong term. That is a non-voluntary deduction, and increase it from 3 to 5%. I just think that's a significant amount of money to be taken out of someone's payroll, and to do it, without asking them in advance. Of course, as I'm sure will be pointed out, you can opt out of the program, but to me, that's not the same thing as it making a conscious effort to opt in. Just going forward, Section 3 actually exacerbates that issue substantially. And what it does is it allows the comptroller to adopt an annual automated increase in the contributions. Okay, so we're already going from 3 to 5%. And now what they're going to do is they're going to increase it 1%. I don't know if it's 1% per year, up to a total amount of 10%. I don't know who's answering my question today. Is it you, Mr. Chairman, or is it Madam Chairman Kushner?
It'd be a combination of us both.
Okay, well, let me ask my colleagues, the two chairmen. Can you tell me what the process is for this automated increase? Is it annual? I thought I saw it there, but I'm not seeing it in the language of the bill. Although I'm virtually positive. Can you confirm that for me, that it's an annual increase of 1%?
You are correct, Senator Sampson.
Yeah, thank you very much. I appreciate that. So think about that for a second. You could be, after just a few years of having direct deposit, not paying close attention to what's coming out of your paycheck, and now the state of Connecticut is taking 10% of your pay. 10%. Now, maybe, it's your money, and hopefully, and we'll get into some questions about that also, you'll be able to have access to that money at some point. But maybe you don't want to use it for that purpose. What gives the state the right to go ahead and decide that for you out of the gate, to the point where you have to make a conscious effort to reverse that policy decision? Just moving on. Some of these sections are technical, but Section 6 says that it allows the comptroller to invest participants' contributions in what is referred to as a capital preservation investment fund. I'm just curious if the chairs might have a definition for what that means.
Senator Kushner?
I don't have that definition. I'm sure we could look it up online or Google it, but I think any questions to those technical terms can be directed to the comptroller's office, or certainly when we get to the floor, we'll have access to all that information for you.
Senator Sampson, I'm sorry.
Thank you, Mr. Chairman. I try and follow the rules as much as the protocol as much as possible. So, but thank you very much. Well, I appreciate that the chairs are not familiar with the term, but to me, this is a very important question. I mean, we're passing legislation here that I could literally, I got a lot of issues here. I mean, we're going to empower a elected officer, the comptroller, to engage in activities which historically have not been something that the comptroller has control over. And we're going to empower them to go ahead and intercept dollars from an employer that are being paid to an employee without their consent. And then they're going to be invested, quote unquote. And then we need to know what that investment vehicle is. I mean, first and foremost, I mean, by virtue of going into an investment product, I think that would mean that folks will not have access to this money till some retirement age. Is that correct, Mr. or Madam Chairman?
Senator Kushner?
That is not correct. They will have access to their money as they would in any other plan similar to this.
Senator Sampson.
Thank you. I appreciate that answer, but I'm assuming that if this money ultimately goes through the comptroller and ends up in a retirement vehicle, that the only way to take it out would be with a penalty. Is that correct?
Anytime an individual sets up individual retirement account, they do so without paying taxes on it. And if they take that money out before retirement age, they are subject to penalties. And I think most people are familiar with that.
Senator Sampson.
Well, I appreciate that. But again, I mean, this we're talking not about people that are going out and actively pursuing a retirement account. We're talking about citizens of this state who are going about their business, who may already have made arrangements to have a retirement account or a plan for retirement. I mean, for me, I mean, I have a little 401k, but I don't even put hardly any money in there because I have a different plan for my retirement. That is, I invest in real estate. So I know that there are some mechanisms in this legislation that say that if you already have some sort of retirement vehicle that, this is less relevant, but we're talking about, money that is going to be, I don't want to use the word confiscated, but taken from, citizens and invested. And it's deeply concerning to me that the two chairs of this committee, and I mean no disrespect, do not know the definition of what a capital preservation investment fund is. I mean, it's deeply concerning to me because I've looked at the website and I understand that, once you make the once that contribution or deduction goes in there, then you might have a choice to invest that money in some other retirement vehicle of your own free will. But in the interim, when it goes in this capital preservation investment fund, we need to know, is that money at risk? I mean, if someone makes a conscious decision to invest in some portfolio or an IRA or mutual fund or a 401k or whatever the heck it might be, they're making a conscious decision about what they're doing. And they are also advised of the risks of such a thing. Well, here you have no advice at all. And we have the secretary of the, or not the comptroller of the state, who's not, as far as I know, a licensed securities broker. Is the comptroller required to be a licensed securities broker, Mr. or Madam Chairman?
Senator Kushner.
I don't believe he is required for that, but I do have information about the Capital Preservation Investment Fund. It's a temporary holding position for the 60-day period after enrollment. It's low risk to no risk.
Thank you, Madam Chairman. I appreciate you looking that up, and I'm aware of that's what it is. And the key words are low risk to no risk, and low risk. I mean, what's somebody's risk tolerance? I know very well that people that are actually in the business of selling financial vehicles like this and products are heavily regulated. They've got to be licensed. They've got to carry different types of insurance. They have to be insured with the FDIC. They got to go through a whole bunch of, hoops in order to be in that industry. And there are many protections in place for consumers to make sure that they're not going to be given advice without being told that, the risk is inherent. Is there any notification on someone's pay stub when the money is deducted that it's being placed in a retirement vehicle and there may be some risk, even if it is low? Through you, Madam or Mr. Chairman.
Senator Kushner.
This process is already underway, and there are a lot of people in Connecticut that are already enrolled in it. And so you should be able to ask any one of the people or the comptroller's office whether there is such a notification. I would imagine there is not. That in fact, it is much more like on their pay stub, it would be more like any other deduction. But as you know, they have the opportunity to opt out anytime, and they can get information about the plan from the comptroller's office.
Senator Sampson.
Thank you very much, Madam and Mr. Chairman. So um, it doesn't appear there's any type of notice that is being provided to the employee when the money is taken from their payroll check. As was just mentioned, you can opt out at any time. But what if your money is already invested in one of these vehicles? Can you take it out at any time at that point?
Senator Kushner.
As I said, you would have the option of taking money out. As you know, it would entail penalties if it's not at retirement.
Senator Sampson.
Yeah, thank you very much. I appreciate that. Can you guys tell me maybe what the status of this program is anyway? I mean, I know that there was kind of a rocky rollout. I know, for example, my girlfriend, who's a municipal employee, she's a teacher, but she had to contact her local school district maybe half a dozen times because her attempts to opt out were not working. But can you guys tell me, I mean, how many people are enrolled? How many people have opted out? Are we still in the midst of a rollout? Because I don't know that this was rolled out to all businesses and all employees at the same time.
Senator Kushner.
I believe there was testimony during a public hearing about the number of people participating, and so you can go back and look at the testimony from the comptroller's office.
Senator Sampson.
Yeah, I think I was here for the comptroller's presentation. I don't remember that data personally. I suppose I can't hold you guys responsible for not recalling it either. And I will certainly go back at that testimony. But my recollection is that it was a relatively small percentage of people in the state that are actually currently enrolled because of the timeline of the rollout and the number of people opting out. I'd love to be corrected if I'm wrong on any of this. Do you know when the program actually began? When the first employees in the state had their payroll deduction begin?
Senator Kushner.
I'm not aware of that time.
Senator Sampson.
Thank you. I appreciate that. There's also the matter of the employer effectively being enrolled as an agent of the state of Connecticut, to be required to roll this out to their employees and keep track of who's opting in and who's opting out, kind of thing. Are employers being compensated at all for taking on this activity, which to me seems like they're acting as agents of the state?
Senator Kushner.
Employers are not reimbursed from the plan, as to my knowledge.
Senator Sampson.
Thank you. I appreciate that, Madam Chairman. So an employer is just being told that you now are a employee of the state. You've got to be in a position to manage, aspects of this payroll deduction as far as this plan goes. And they're not being compensated for it at all. That's just the state telling people what to do. I don't know why any of us think that's okay. I would be concerned with that. And second of all, it looks like Section 7 expands or addresses the potential penalties for an employer who does not or fails to follow through with the processing of the employees opting in or opting out process. Can one of you guys maybe expand on that for me and tell me what is changing in this bill regarding the potential penalties an employer might face?
It does create a requirement of financial penalty for non-compliant employers, and then thus allowing the Labor Commissioner and Comptroller to sue them under the current law.
Representative Sanchez, if I might add.
Senator Kushner.
I would like to add that it is clear, and from a policy decision that was made when we enacted this Connecticut retirement program, that we believe this is good public policy. I know we don't agree on that, Senator Sampson, but certainly that is my view. And just to answer, and so we do want employers to be required to follow the law. And so it is not untypical that when an employer does not follow anything in something in the law, then there are penalties, and that's what this change will allow for. We do know from previous testimony from the comptroller that they are very reluctant to go to the Department of Labor or engage in penalties, because their ultimate goal is to get people signed up and involved. And so I believe we've had testimony before about the opportunities that are given to an employer to correct any mistake they might make with regard to failing to file. To answer your earlier question, I've received information that there are 6,300 employers in Connecticut that have already signed up, and 25,000 employees are currently covered, and $18 million, there's been $18 million contributed in savings.
Senator Sampson.
Thank you very much, Mr. Chairman. Thank you, Madam Chairman, for that information. There's a lot to respond to in your response to my question. The first thing I would say is that we certainly do differ on whether this is good public policy or not. I think this is absolutely horrible public policy. I find it offensive that the state government thinks it has the right to not only draft the employers to engage in the confiscation of taxpayers' money for this purpose. The fact that the state government wants to go into business competing against the private sector for retirement, the fact that this process it requires an opt-out instead of an opt-in, to me is the most disingenuous piece of the whole thing. If the fact of the matter is, if this was a really good program, you would have people opting in all over the place. But the fact of the matter is, people can opt in to a retirement program anytime they want anyway. They don't need the state of Connecticut, and they certainly don't need the labor committee to engage in doing that. And thank you for the numbers, by the way, because I mean that's a pretty strong illustration. I mean, in the entire state of Connecticut, a state of 3.5 million people, we have 25,000 employees are currently included. That's it. So this rollout is pretty significant. And I also want to just correct both of the chairs on their comments regarding the penalty aspect of it. There's no lawsuit involved. There is no Department of Labor involved. What you have is the comptroller is the lord and king of this program. And if they decide that somebody has not complied, then they can actually just fine the business. So we're empowering the comptroller in a big way here to say that they can, number one, go ahead and create this program to take people's money that doesn't belong to the state of Connecticut. Remember, this money belongs to the person who earned it. It is their money. For me, I don't, if I was in any type of relationship where someone wanted to take the money that I earned without asking me first, I would have a significant concern over it. And that's what's happening here. I also I can't stress enough the fact that there's a risk involved with this money. So we're taking folks dollars from them when they presumably people that are having money taken from them have already decided whether or not based on their freedom of choice every day to pay attention to all the fidelity ads that they see on TV and hear on the radio and in print to either have a retirement account or not. So the goal here, which I understand, I hear my colleagues on the Democrat side, saying this is a good policy. People should retire. People should do a lot of things. People should stop eating so many bad foods. People should not smoke. People should stop drinking. People should invest money for their savings. People should walk more. They should exercise more. What are we going to do? Are we going to go into people's houses and tell them you didn't do your 15 minutes of exercise there, Senator Sampson? You're going to have to do it now. I mean, at what point do we let the citizens go back to being free people? Is the question that I have for state government and for this committee. You know, free people engage in commerce. They don't need our help. They're out there right now. Employers are, doing business and creating products and running companies and creating new products, and employees are voluntarily engaging with them and getting hired to do work. And they're negotiating the terms of those agreements on their own. They don't need us. They don't need us sticking our nose in there, telling them what goes between their contract. We don't need them, the state government, to tell people that, part of your paycheck, you should be investing in a savings account. So we're going to do it for you because you didn't do it for yourself yet. It's an absurdity to me in this country, which is a country founded on the notion that people are free and that we have a government because we have to, really, because we need it for certain purposes. And mostly the purpose is to protect the rights of the citizens to be free people. That's the number one purpose of government that's been lost over time. And the second purpose is to make sure that we protect private contracts. So that's not what this government does anymore, though. This government throws both those things on their head and interferes with those private contracts instead of protecting them, and deprives people of certain rights instead of protecting them. It's a major failure to understand exactly how our system is supposed to work. I encourage folks to read up on the founding of our great country and why we've been so successful, over the course of the last couple hundred years. It's because of freedom and the desire for people to engage in commerce freely with one another and to associate freely with one another. And that's all going away. That's all going away as the state, and by state, I mean the state of Connecticut and the federal government as well, decides to have more and more control over the individual activities of people. And what it ultimately does is it means that people not only have less freedom and less decision-making, they also don't even know how to use their freedom and decision-making when they have it. So we're in a very dangerous spiral towards more control and an authoritarian society. And this concerns me when I see the state more and more each year deciding that they're going to get involved in different types of industries. We had legislation discussed this year about how we're going to force people to buy a certain type of vehicle. You're no longer going to be able to buy a gas-powered car, kind of thing. I mean, it's like, where is the fact that we work for our constituents? That should be the paramount thing that each of us ask ourselves anytime any bill comes before us. Are we depriving people of their freedom of choice to make their own decision? Well, this bill takes people money out of their paycheck without even asking them. Yeah, there's an opt-out, Rob. Well, okay. Well, why not make it an opt-in then? And why do you need to compete with the private sector for doing this? I will put down my soapbox for a second and just continue with the Q&A. Does this program affect all employees in the state of Connecticut, Madam or Mr. Chairman?
Senator Kushner.
This program, I believe, is for all employees. It's for all employees of employers who do not have a program set up within their company.
Senator Sampson.
Thank you very much. I appreciate that answer. So you can avoid having to participate as an employer and therefore protect your employees, but only if you do what the state wants you to do first, is what I got from that. Is that correct?
Senator Kushner.
As I said, if the employer has a retirement program, they are not required then to follow this statute. And it is restricted to employers with at least 5 employees.
Senator Sampson.
Thank you, Madam Chairman. A few questions in there. What I was getting at was, does this apply to employees that are collectively bargained?
Senator Kushner.
If a contract if there's a collective bargaining agreement that includes a retirement program, then it would not apply to them because, as has been said, they would already have a retirement program.
Senator Sampson.
Thank you very much, Mr. and Madam Chairman. Yeah, so cleverly, this policy has been drafted in a way that allows collective bargaining agreements to escape the mandate. I find it interesting that if it's such a great idea, why it doesn't apply to down to one person. I know that that's where we're going everywhere else. We got paid sick days legislation, which we all agreed was too onerous to try and apply to small businesses, and therefore limited it to only businesses with over 50 employees. And now we're changing that this year, saying, well, it's a good policy, it should apply to everybody. Well, this particular proposal, this is not the first go round for this thing. Is there a reason why it's limited to businesses only that have 5 or more employees?
Senator Kushner.
We are not trying to change the number of employees in this bill.
Senator Sampson. Good mic.
Thank you. I appreciate the answer. I guess I've asked all my questions. And I think I've kind of along the way expressed my concerns with this proposal. But I'll just end with this final comment, which is that, despite the fact that, I made all my own, concerns very clear about, the fact that this is a mandate on employers. Employers are not being compensated, but in fact, they are only potentially going to find themselves on the wrong side of the comptroller, which now has this godlike power to be able to find people, who don't comply with his demands. And I nothing personal against the comptroller. I happen to like the comptroller very well personally. I'm speaking about him as in the terms of his office and whoever may fill that role in the future. And we should always remember that when we're referring to legislation that affects various individuals that serve in our state government. And then, of course, I made it very clear how I feel about the notion that we're effectively confiscating dollars that don't belong to us as a brand new an additional payroll tax on top of all the other payroll taxes that people are already paying. And really, I mean, I defy anyone, regardless of their income strata, to say that they're not being taxed too much already. And for those folks who don't think they're being taxed enough, I encourage them to give more. And maybe save the rest of us from being taxed so much. But the final issue I have with this, more than anything, and I think it's kind of an overall thing, is that the state of Connecticut, when we pass legislation, one of the factors we're supposed to be looking at is whether the state has any good reason to do this at all. It's called compelling interest. I brought it up in a committee the other day too. People look at me like I got 3 heads. The fact of the matter is, the state government needs a reason to be writing laws. Not to keep us busy, not because we're meeting here and, oh, geez, what are we going to do? Let's come up with some new clever idea. We need a compelling interest, especially when we are interfering with the freedoms of the constituents that we represent, and that we all, by the way, put up our right hand and swore that we were going to protect their freedom and their autonomy as American citizens and residents of Connecticut. And I don't see a compelling interest here. These products exist already in the marketplace. There's no restrictions. They're incredibly easy to activate and come across. I mean, you can walk into an office in almost any of our 169 towns, probably all of them, that somebody is doing retirement funding. Virtually every bank will offer similar products. You can go online and get similar products. You do not need to have the state engaging in this activity. And of course, even if you were doing this voluntarily and you like the idea, know that you're being limited by the state of Connecticut on the few different choices that you have on what you're going to invest in, instead of the whole world of choices that actually exists out there. The state of Connecticut's got really no business entering into this process. And I think it's dangerous on several different levels. Number one, it's effectively making it a credible idea that the state can compete with private industry and that they can take funds directly from paychecks without consent, without prior consent anyway. And for those reasons, I'm a hard no on this bill, Madam and Mr. Chairman, and I will just suggest that I've only touched the surface of things I really want to talk about on this, but I will save that debate for the Senate floor.
Thank you, Senator Sampson. Any further discussion? Representative Weir.
Thank you, Mr. Chair and Madam Chair. I do share some of the same sentiments, but I have some questions that came up in reviewing the bill. So can you, and again, I'll direct them to both of you, and whoever would like to respond, please do. Do we have any data on the return on investment? So if an employee is compelled to have their wages taken through this retirement program, what is the data that shows the return on investment, and where can we find that?
Senator Kushner.
Just give me 1 minute and I will look it up. There is an annual report distributed to employees and to employers, and I don't have the exact amount handy, but I'm sure we'll have it in time for the debate on the floor or well before that. I'm sure we can get that information for you.
Representative Weir.
Thank you, Senator. Thank you, Madam Chair. So as a follow-up to that question, is that annual report, is that provided prior to somebody investing, or is that like a year in review, kind of a rear view mirror view of how things performed over the year?
Senator Kushner.
I believe it's an annual report, not provided, but certainly not provided in advance or every time somebody enrolls, but I'm certain that a person would have access to the previous year's annual report if they're enrolling at a time in between annual reports.
Okay, thank you for that answer. And I asked that because I've been a owner of a small business, and I've also been an employee. And I know that when we were, as an employer, working with a private sector investment professional, I mind you, with somebody with a track record and history and all the credentials that go along with investing people's money, we had the opportunity where several plans were presented to us. I also, by the way, have that ability as an employee, and you had choice, and they're able to, from recollection, you know, the reports are given, and here's been a historical performance of this fund or that fund. Here's our projections. Now, of course, nobody can go on projections that, you know, you can, that nobody has a crystal ball, but some level of expectation on how future performance will be based on years and years and years of track record. Some of these funds have been in existence decades, you know, since the 1960s, 70s, 80s. So the fact that a prospective employee, investor, I guess, that we're putting them in the position of a fund and an operation with so little track record, and then no real visibility other than an annual report. I mean, I could log into some of my accounts and see the performance this week or yesterday, although they tell you never to do that because then you get nervous when things go up and down in short term. However, having that visibility, it doesn't sound like that's provided to members of people who are forced into this plan. My next question would be, does the state provide a match, employee match?
Senator Kushner.
There is no employee match. It would be the employer that provided it. It's not required by the state or by this statute or by this program, and the state does not provide a match.
Representative Weir.
Thank you. And the reason I asked that, also having been an employee and an employer, is that oftentimes it's advantageous to both the employee, oftentimes an employer will make a match of a certain percentage to an employee. And part of that is to incentivize the employee to save, right? Because they're getting a 1 or 2 or 3% match for nothing, right? The employer is kicking that in. It's advantageous to the employer. There are some tax advantages to that, and both parties make out. The employee ends up with extra contributions on behalf of the employer, and again, it's voluntary. So thank you for that answer. Want to skip to page 2, line 34, and I noticed that this is subsection 3, I guess. Section 1, subsection 3. And we're talking about a covered employee, and it looks like the period in order to which to be qualified. And originally it was 120 days, and now in this legislation, that's been changed to 30 days. So is that my understanding that an employee can be signed up for this program within 30 days of employment? Mr. and Madam Chair?
That is correct, Representative Weir.
Do we know the methodology behind that? I'll just, again, speaking from experience, some employment, retirement plans, you can't always sign up for those right away. There's a lot of paperwork, there's a lot of back end work, and usually there's maybe a probationary period for an employee. Who knows? First 30 days, you may have somebody working there a month, and they say, geez, this place isn't for me, or it's just not a fit, or whatever. And there's a lot of work that goes into an effort signing up. Not a terrible amount, but it's enough. It's work on the back end. It's for the employee and the employer to make this arrangement work. So I'm curious as to how that number of 30 days was arrived at, because I've not seen that typically in my history of working for someone or employing people.
Senator Kushner.
I believe that the reason behind this that we heard in testimony from the comptroller is that the sooner someone starts saving, the better for that person when they do reach retirement age. As you pointed out, I can understand why some employers might not want to do it after 30 days, because in many cases they're making a match, and most employers would not want to do that before they're certain the employee is going to stay and stick around. In terms of the amount of work on the part of the employer, it's very little work. They just have to register with the comptroller's office and give the names and contact information, and the plan does the rest. So it is very little effort on the part of the employer. Bottom line, the sooner people start saving, the better it is in the long run in terms of having a secure retirement.
Representative Weir.
Thank you for that answer. So and just caused me to think of one more thing. So if, let's just say that the employee gets enrolled into this program, and then something doesn't work out at day 60, and they're off to a new employer that has an existing plan, does that put in any way, they have let's just say they have a qualifying plan. What's the process for moving this money over to the plan of the new employer who has a qualifying plan? Is there a penalty paid to move it from one retirement account to the other? Senator
Kushner.
Just keep in mind that this fund, this money is the individual's money, so they're not required to move it in order to gain access to it. They could either keep it until they retire, or they could cash it out. In terms of whether or not there would be a charge to move it to a different account, I think it would really entirely depend on what the new employers in the new employer's plan. I'm sure that there would be particulars about whether or not you could move money into a new plan. So I think that I am confident that this would determine entirely on each individual case.
Representative Weir.
But as you know, this is not, I mean, it's the person's money. It's not the state's money. So they can choose to do whatever they want with it at any time.
Representative Weir.
Thank you for that answer. And again, I just, and the reason I ask is because, you know, I've uh, had the opportunity to, you know, we, even within our business, we've changed, you know, our local financial person came and gave us the option and said, you know, there are other plans, there are different options this year, or, you know, we've come across something that we really like and we would suggest, you know, our recommendation is to move it. And so, you know, there's a process by which, you know, we move from one, you know, company A to company B, the investment company A, that is, and, you know, there's a back end process, but the employees, you know, there's no chance that they're penalized in that process, right? So their money, if they had 10,000 in, you know, there's no fees, there's no penalty to go from one private plan to the next. But my concern is that if the employee goes from employer A, who is relying upon the state's plan, and that doesn't work out, and then the employee goes to work for employer B, and let's just say their plan is better. They have a 30-year history of a better return than what we're seeing here, and they want to take their money from the state plan and move it to the private plan. You know, I want to make sure that they have that, since it is their money, that they have the ability to move that without penalty and hopefully without, you know, hopefully there's a process. So I'm just, you know, obviously we want to encourage people to invest and invest early. I agree with that sentiment 100%, but also to have some semblance of control over where that money goes, not just when it's with the state, but if there's an ability to pull it out and move it to another qualifying account without penalty. Is there any way to get that assurance today, or is that something we'll have to find out later through you, Madam or Mr. Chair?
Senator Kushner.
As far as the state's concerned, the plan is portable, so people can take it to another plan. But as I mentioned, you know, if they're going to an employer who's got a different plan, it is also, I'm sure, subject to the rules of that plan that they're going into. But as far as the state is controlled, there's no penalty for moving your funds. It is a portable plan.
Representative Weir.
Thank you. I think you know, I'd like that on the record. I think that's something that is, you know, if this moves forward past today, that we, you know, really look to make that very clear, crystal clear for people who are involved. Because I mean, even today, somebody who's working at a, you know, for the requirement's 120 days. Well, if it doesn't work out after 180, we want to make sure that they have that portability and flexibility and guarantee that they're not penalized for making a choice of career. You know, want to make sure that the state's plan is keeping up with what's offered in the private sector. Thank you. Okay, my next question, if I may, is I guess section 6. We're talking about a qualified employer. So starting with lines 41, but I really jump into 47. Actually, this isn't even a question. I just want to point out that you know, those entities which are excluded, do not consider a qualified employer, would be a federal government, state, or, you know, the state political subdivision. They're excluded from complying with this. Any municipality, they're off the hook. And any employer employing only individuals whose services are excluded under subdivision 5 of subsection A of section 31-222. And I probably missed it, but what is section 31-222? What type of employees follow under 31-222 on line 52?
I believe our LCO is in the room and can look that up. And I'll look to see if I can find it as well. But we can ask LCO if you want to take a pause.
Thank you. And I know this is existing language, but just for my own reminder, I appreciate that.
So that section is in the unemployment chapter, so that is referring to things that aren't covered under unemployment law.
Representative Weir.
I'm sorry, but can you repeat that? I don't quite catch that. Layman's terms.
It's the types of jobs that wouldn't be qualify for unemployment.
Representative Weir.
Is that a real long list, or could you give me a couple examples of what that, one or two examples that I'm?
If you're working for your parents, for the US government, certain provisions under congressional acts.
Okay, I don't want to belabor that. Working for your parents' part, that, you know, I think we've all done that at one point or another. I never really was properly reimbursed for my mowing the lawn. I'd like to point that out. Yeah. Okay, let me move on to, I'm nearing the end of my, well, more than halfway there, put it that way. What I would like to talk about is a measure of concern, and that's, what section is it? Section 2, line item J, so 134 through 138, and it talks about, it looks like it's, I'll just use my language, to hold harmless for members of the board, as it relates to their duties, it looks like, and that the controller can indemnify and hold them harmless, you know, with, if they're, and I don't know what chapter 574 is, but it looks like there's some sort of indemnification for the board members who are making decisions with people's retirement money. So I don't know if that, you know, if they acted in malfeasance, if this is just, you know, if they made a bad investment decision, but, you know, since I don't believe the board is acting as a fiduciary to the person whose money they're working to invest, I mean, do we know if this mirrors what happens in the private sector investment? Why do we have this this line indemnifying members of the board and not just the board, the Connecticut Retirement Security Program? It sounds like. So what, question one, does this mirror what happens in normal financial industry? And number two, why is this paragraph in here to protect board members or members of this this security fund program?
Senator Kushner.
In order to get an answer of what happens in the private sector, investment sector, we'd have to get an expert on that subject matter. But I do want to refer you to testimony. I recall this came up in discussion during the testimony of the comptroller, and there were questions asked about it. If you want to hold, we can ask our OLR, one of our members here from the Office of Legislative Research, to go back to the testimony and find that if you need assistance in finding that.
Representative Weir.
Is this some, I mean, I don't have to have that this minute if it's going to delay us along. I mean, if it was readily, could put our hands on it, then I can, at some point, I would like to see that, I think, before we, you know, for future discussion, if that's okay. But it does, so the question is, question number one, does this mirror the private sector? And we're going to look into that. And then same thing with the, why this was added to protect them. So I guess we'll look at that down the road. Thank you.
Yep.
Okay, so now I would like I want to compare two paragraphs, one, line 165 to 168. And maybe this is just me trying, the way I'm reading it, but it says the 165, the amount and method of collection of such fee shall be determined by the comptroller. No employer shall be required to fund or be responsible for collecting fees from the plan participants. So that's one. It says to me that the controller, the employer doesn't have to collect the fees from the employee. The participant, I'm assuming, is the employee. But then we jump to line 275, and it says, if a qualified employer fails to enroll such qualified employers covered employees as required in subsection 31-4422, then there are civil actions and penalties. So it sounds to me like how does the employer enroll, but then how are they not responsible for collecting? I mean, how else do you get deductions if it's not deducted from a payroll? So I'm unsure how line 165 protects the employer, or how. I'm reading those as conflicting, and maybe I'd be happy to be corrected.
Any other
Yeah,
questions?
thank you. Give us a minute and we'll see if we can answer that.
Yeah.
And I'm sorry, the copy that I have available does not have line numbers. Could you give me the section numbers again?
Oh, yes, 165, oh, you don't have it. You want me to,
Just-
oh, section number. My goodness. Well, I'll tell you, page, section 3, subsection 3. Bottom of that paragraph. And it's existing language, I might point out. And that was one of them. And the other was section 7, subsection C1. It's really the entirety of 7C, because you talk about fines and all sorts of things if the employer doesn't enroll an employee. So I'm just trying to figure out question is, how
Can
can
I think I know where you're going and what I understand. The first section is about the deductions. Those are the responsibility, as you pointed out, from the employer must make the deductions from the employee. The second is about compliance fees. If there were any questions about compliance, the employer is not responsible for that.
Representative Weir.
Okay, thank you. And I'll just confirm that I don't have any more. I think I'll wrap up here with no more questions, other than to note that I had concerns with this program from its inception. I mean, I think we're further ratcheting down control over the employee, and now we're, really making the employer complicit. We're adding more burden for the employer. Fines. We shortened the time of employment for the employee, so that's, the employer has to act quicker now. Instead of having 120 days, they have 30. That's 4 months to 1 month. We've gone to, this is already, not necessarily of one's free will, right? I mean, this is not an opt-in, it's an opt-out. So so we've added not only burden to the employee, but the employer is burdened. And, I saw recent data that, Connecticut's still, number 47 when we talk about economic, friendly to do business in the state. And I'm going to harp on that number. I mean, I think we're shooting for 49, and let me just tell you, 50 is the wrong direction to go. I don't see why this can't be. I understand the importance of saving. I'm not sure why it can't be voluntary and willful, why we don't focus on education about how important it is to invest and have your money working for you while you're working as well. But to put this on the back of the employer and an unsuspecting employee, and then further tightening up, kind of railroading this process, I have a hard time with it. So thank you for listening and answering my questions. I appreciate it.
Thank you, Representative. Any further discussion? Representative Yacarino.
Thank you, Mr. Chair. I'll be very brief, and Madam Chair, I'll be very brief, but I do have a question for clarity. I do oppose this legislation. I posted on the floor a number of years ago. It's against all free will and commerce, I believe, and freedom. But if I invest, I participate, obviously, and I have $5,000 or $10,000 with the comptroller's office. Could I call somebody and say, I want to move that money into NVIDIA, or I want to move it into Meta? Do I have that option, since it's my money, to move it freely to you?
Senator Kushner.
Give me a minute to look up the answer on that. I know that we answered earlier that it was portable, and I believe that means that you can move it. But give me 1 second, see if I can just confirm that. So the answer is, as stated, yes, you can move the money, but there are defaults that take into account that the assumption is being made that you are going to stay in the fund until your retirement date. So moving money from one fund to another is possible because it is a portable fund, but as is in the private plans, as you've discussed, there are assumptions built into it that are based on staying in the fund until you retire. So you talked about penalties. This would be, I assume it would be dealt with the same as it would be if you were moving from one private plan to another, moving your money.
Representative Yacarino.
There's nothing on the state side that makes it exceptional.
I appreciate that answer. My issue is, though, if I'm investing money, it should be my decision, anybody's decision, to invest that money wherever they want to invest it. The money's taken out of somebody's payroll now, they might not know it's going, and listen, people should invest, I get it, into a mutual fund. They might want to invest it in a stock or 2 stocks or 3 stocks, or make their own portfolio. The state's taking people's personal money and doing what they want with it when they don't have the say unless they move at the end of the year to another fund. And I think fundamentally that's just un-American. Again, I think we should save, like Representative Ware's mentioned, Senator Sampson, but the fact is it's people's money. And for the comptroller, who I like quite a bit, their office or the board members are not held to a civil penalty, but business owners are. To me, it's egregious. Just not a fair playing field. Again, a laudable policy, but it's a laudable goal, but a bad policy to get there. It's people's personal choice and freedoms in this world, and we're losing it little by little. So I oppose this legislation, and I think it should be somebody's somebody's choice to do what they want with their money. Thank you.
Thank you, Representative. Any further discussion? Any further discussion? Seeing none, Ms. Clerk, please call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 1. Senate Bill 136, an act making changes to the Connecticut Retirement Security Program statutes. The motion is to JF this bill to the floor. Senator Kushner.
Senator Kushner votes yes.
Representative Sanchez.
Representative Sanchez votes yes.
Senator Cabrera. Representative Wilson,
Representative Wilson votes yes.
Senator Sampson,
Sampson is no.
Representative Weir,
Weir's no.
Representative Ackert,
No.
Representative Belton,
Belton votes yes.
Representative Hall, Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Yakarino.
Representative Yakarino votes no.
Thank you, Mr. Chairman.
Thank you, Mr. Clerk. Votes will be held open. I'd like to entertain a motion to J up to the floor. Item 2, SB 29, an act concerning working conditions.
So moved.
So moved.
Seconded, Rep. Hughes.
Seconded by Representative Hughes. This bill requires the Labor Commission to study working conditions in the state and report to the Labor Committee by January 1st, 2025. Any discussion? Senator Sampson.
Mr. Chairman, am I correct that this is what's commonly referred to as a dummy bill or a placeholder?
Senator Kushner.
That is correct.
Senator Sampson.
Thank you for that answer. Is this the only one on this agenda, or are some of these other items also going to fall into that category?
Senator Kushner.
There are other items on the agenda that would fall into that category.
Senator Sampson.
Yeah, thank you very much, Madam Chairman. Thank you for Mr. Chairman. Can I just ask why? I mean, and the reason why I ask is, I mean, we've had this conversation many times. There is a process here at work that we're supposed to be following. The idea is that, individual bills are proposed by members or the committee, and then we put those ideas out in front of the public so that they can come and speak in front of us and let us know, their perspective. Is it good? Is it bad? What should we change, and so forth? And when we're using these placeholder bills, which for people watching are just basically a title with some brief language that is not intended to go forward. It's just there to take up space in the meantime until potentially something else is is put in its place. We're skipping over that process. We're denying the public any input on what any of these placeholder bills might become. And I fully recognize that there are situations that can occur where you might want to be prepared in case something comes up and have a what's referred to as a vehicle to maybe put some certain topic into language. But boy, we got a lot of bills already. I think we've got bills that cover every topic under the sun that could come before this committee. And we've got several different placeholder bills. I'm just trying to understand from the committee's leadership what they're considering. I mean, are we going to see these placeholder bills show up on the floor of the House and Senate and have different language inserted? Is that what's going to happen?
Senator Kushner.
Certainly, we have done this in the past, as you know, since you've been a member of this committee. You know that this isn't unusual and not unusual this year, as opposed to any other year. And whether or not it will end up a bill that comes forward on the Senate floor or the House floor is to be determined. But it is, as you point out, a possible vehicle, if necessary, to insert good policy, which is our practice. Thank you.
Senator Sampson.
Thank you for the answer, Madam Chairman. The only thing I might correct in your statement is that there is no we, because I'm certainly not an active participant in how this committee puts together its agendas and determines what bills are going to be heard or debated or even voted upon. And I do not approve of the majority of the items on this agenda. I don't approve of the placeholder items ever. I don't think historically I voted for one. I was taught early on by a colleague that those are objectionable items from almost a universal perspective from the minority. So I'll just register my objection on this placeholder and let that also speak to the other ones as they come up on the agenda. This is not the way we should be conducting business. We should be using the committee process as intended as a mechanism to allow the stakeholders to have input. And we should really debate these bills with the full knowledge of what we're debating about. You know, we just got through debating the retirement security proposal a moment ago. And, you know, there seems like a mile of unknowns. You know, the unanswered questions, confusion about exactly what, some of the terms in the bill are and what the policy actually is. We need to care more, Madam Chairman, about what we're passing as laws. These affect the residents of the state. The 3.5 million people who live in the state of Connecticut have to live with the decisions that we make here. We should know absolutely 100% full well what those things are, and they should be vetted and fleshed out. And the public has an absolute right to be a part of that process. And placeholder bills skip the public. That's my main objection to them. Thank you for letting me vent.
Thank you, Senator. Any further discussion? Seeing none, Mr. Clerk, please call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 2, Senate Bill 219, an act concerning working conditions. The motion is to JF this bill to the floor. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Sanchez votes yes.
Senator Cabrera, Representative Wilson,
Representative Wilson votes yes.
Senator Sampson,
Sampson is no.
Representative Weir,
Rep. Weir is no.
Representative Ackert,
Ackert is no.
Representative Belton,
Belton votes yes.
Representative Hall, Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Yakarino.
Representative Yakarino votes no.
Thank you, Mr. Chairman.
Thank you, Mr. Clerk. Votes will remain open. I would like to entertain a motion to JF to the floor. Item 3.
Rep Hughes so moved, but you want to say what it is?
Yep, SB 222.
So moved.
Okay, so moved by Representative Hughes, seconded by Representative Wilson. This bill makes various changes to the state's paid family and medical leave insurance law, Family and Medical Leave Act, and Family Violence Leave Law. Discussion. Representative Ackert.
Thank you, Mr. Chair. We've had this in place, the law exists, so we have the policy. Couple areas that I have questions on in this one. The penalty component of it that is listed on lines 130 or 132 has pause for me because of that penalty component of it. That's probably one of my biggest objections to this. But I do have questions regarding the sections that deals with overpayment and repayment. Are you aware of issues that, because I know it takes a bit to get paid, and these are lines 272 essentially through like 295, those areas, and that they've actually overpaid and then tried to get the money back, and there was no policy in place to insert that through you, Mr. Chair?
Representative, I made an error on the mechanism to move the bill, so I'm going to actually have to repeat that, and then we'll go into your question. I apologize. So I'm going to entertain a motion to JFS SB 222 enact changes to the paid family and medical leave statuses.
So moved. Rep Hughes.
So moved by Representative Hughes, seconded by Representative Wilson.
And Representative, can you state the LCO number on that?
LCO number 2702.
Thank you.
Discussion. Representative Acker, I apologize.
Since you so eloquently restated your comments, I'll do the same. So my pause I mentioned earlier, it deals with starting with lines 130 through 132. Any employer that fails to comply with the provisions of the subsection shall be subject to penalties established by the authority pursuant to section V, section 3. So whenever you have a shall in here, that does not give the department, so I'll expand on this, any ability to put in a warning, or something like that. So I get a little pause on that section. And I would always, because we have departments in labor, Department of Labor that has laws, in the Department of Labor that you have penalties, and they said, boy, I wish we could do like a warning or reduce payment, or they do some negotiations, but they know we have to because it's in law. So that shall component, is a pause for me on supporting this. But new language, lines 272 through 295, deals with somebody that's received money but over the amount of what they should be paid. First, I'm concerned, why are they getting overpaid? And then the penalty component of it that goes along with that if they don't pay it back. So is there, I take it there's history of this happening, and then the paid for medical leave, is trying to recoup it. So do you have an understanding of why this section's in here?
Senator Kushner?
Just give me 1 minute. As I mentioned, I don't have a copy accessible with the line numbers. So if you could tell me the section.
Absolutely, Senator. 1 second. So section 4, 6th and 7th paragraph, I believe. Section 4. I think 7 and 8, paragraph 7 and 8. It starts with any person who's received a greater amount of benefits than was due.
One second to get there.
While you're looking, I just would like to say that I have had 2 employees actually had used this. They were hurt outside of work, thankfully. Not that they were hurt. I don't want them to be hurt ever, but it wasn't not a workman's comp. And so they did use it, and it was so helpful for them. And I did reach out to them on another issue, the department, and they gave me an answer back in prompt time. So regarding if somebody under the 18 has to submit payment on this, and they do, which I was kind of shocked, but I just want to give kudos to the department.
Well, I appreciate that. And I can tell you that the most common reason for an overpayment is someone might go back to work without notice early before they had intended to originally in the time that the leave was applied for. And in such case, they would get an overpayment. The other reason that has happened is if employers provide incorrect information about coordination of benefits, and then they correct it after the fact. So there might have been an overpayment in that instance as well. I do want to agree with you that I have found that the authority is doing a really good job of answering people's questions or when they have a concern. So we, I think, all agree on how important the program is. There have been very little incidents of overpayments, but it hasn't been and never will be 100% correct because of these reasons that I formally stated.
Okay, and I appreciate that that answer. Yeah, I just the part that if they don't pay it back in a given time frame, who knows if that person's obviously you're in a tough way anyways. In some cases, when you're using this, that you need the money typically, and you paid into it. But then the penalty component has some pause. And I want to just add that I am in support of the section which deals with adding individuals that have been abused, sexually abused or other in this. So I do want to support that. The penalty component has me some reservations in supporting this out of committee at this time, but I may reserve my right to change that. Thank you, Madam Chair and Mr. Chair.
Thank you, Representative. Any further discussion? Representative Yakarino.
Very brief. I do agree with Representative Ackert. I would like to support this, but the penalty part really gives me pause, so I cannot support it. Thank you.
Thank you, Representative. Any further discussion? Representative. Senator Sampson.
Thank you very much, Mr. Chairman. Sorry, we're all chomping at the bit to debate this bill today. So, yeah, where to begin? We're having a little difficulty over here on our side in the minority, partly because we're trying to grasp the changes in the substitute language. For people watching, sometimes this happens where, you know, various changes are made to the language before we vote on it, and sometimes we get those changes at you know, a late hour, and there's not a lot of time to digest what's really happened. I don't think the changes are substantive in the bill proposal. Can you confirm that for me, Mr. or Madam Chairman?
That is correct. They're not substantive. It's about changing a date of reporting, which makes it streamlines things for the authority. So, and it was a last minute addition that made sense to us.
Understood. I appreciate that. Certainly. It's just sometimes, you know, when you have your notes written on one document and then you have a replacement document, maybe you don't have your notes lined up, or the line numbers change or something like that. So this policy is about making some alterations to the paid family and medical leave statute, which is another policy similar to the retirement savings account that was imposed by the state without any ability for citizens to opt out. In fact, to this day, I think there are people that are paying into this fund who do not have the ability to actually receive the benefits. It's a proposal I put forward every year that doesn't seem to get attention. But that seems ridiculous to me, that we're like, you know, taking taxpayer dollars again, without an opt-out provision at all in this particular case, and effectively using them for this purpose. And again, it's a purpose that exists in the private sector. You can buy disability insurance, short or long term. You can buy health insurance. You have mechanisms that already exist. You don't need the state of Connecticut undermining and competing with these private sector industries to create this type of policy. And, you know, these are like some overbearing terms. And this is the thing that I think that the public doesn't always get. You know, they're hearing nice commercials about some random person who was helped by this program, but, you know, they don't tell you, well, we're also taking, you know, a payroll tax out of your paycheck, and we didn't even ask you first whether you need this or not. So that's where your money's going, to help some nice people. And, you know, where I come from, you know, if I want to decide to help some people that need to be helped, that's a decision that's called charity. And we shouldn't be looking at, you know, our political class and our state government, who's very good at, you know, taxing people and redistributing the wealth. And maybe some of it ends up being used for good purposes. I won't deny that. But the fact of the matter is that's not the same thing as charity. And no one's being generous by taking one group of people's money to give it to someone else. And we've got to stop looking at government in that framework. The bill that's before us doesn't make a whole lot of significant changes. The biggest part of it probably is the part that has to do with the memorandum of understanding with the tribes, which I'll get to in a second. But I do want to talk about this penalty situation that my colleagues brought up. I think it's actually kind of bizarre. I mean, first off, there's penalties for everybody under the sun in this proposal. Failure for an employer to comply with provisions, civil penalty plus money owed. I have there. Can you, Madam or Mr. Chairman, enlighten me on what the penalties are for the failure of an employer to comply with the provisions of Section 2?
Senator Kushner.
Before I do that, I do want to correct a previous statement. That's why I raised my hand. When you asked about the S language, I was thinking about the streamlining dates that were already in the existing proposed bill. The S language is simply changing the effective date of the legislation so that the authority has time to make sure all their programs are in place to be able to accommodate the changes that we're making here. So it really is just pushing out, instead of a July 1 date, it will be pushed out to October 1 to give people the necessary, to give the authority time to make the necessary changes in the programming. So I just wanted to correct that for the record. Going back to penalties, most of our statutes do have penalties when someone does not, when we're enforcing the statute. In order to enforce it, in many cases, we have penalties, and it is not uncommon for part of the penalty to be paid back the amount of, say, an overpayment. So I think essentially it's a pretty small penalty, or it's $50 penalty or 10% of the outstanding balance on employers who don't remit contributions. Also, regarding penalties, the fundamental fairness requires that people comply, and if they don't comply, there would be penalties in place. So essentially, $50 is the penalty, or 10% of the outstanding balance that the employer has not remitted.
Senator Sampson.
Yeah, thank you. I appreciate those answers. I might disagree that most of our laws have penalties associated. I don't know that that's actually true. Someday we ought to do a study about the requirements for various types of statutes. Certainly laws regarding mandates on municipalities, boards of education, so forth. They rarely have penalties associated with them. I mean, there's the implied penalty that the state can withhold funding or something like that. But we write an awful lot of mandated requirements for citizens and municipal government that don't have penalties associated with them, even though they're indeed laws. This one here is 10% of the balance outstanding could be a very substantial amount. If you had a corporation that had a number of employees and there was some sort of calculation about the amount that was supposed to be remitted. Again, you're telling a private employer that they are now the employee, the free employee. I don't even know if you're an employee at that point. I don't know what you would call someone that you're making work for you without paying them. But that's what the state is doing to these employers by putting them in this position to collect these funds and track it. And now, not only are you being requested to do work for the state, you're also, and again, I will repeat my comments from before, that the state has no interest in this situation from the employer-employee relationship standpoint. If the state is so interested in taking people's money and creating a paid family leave program, they could do that, but they don't have to go through the employer and impose the requirements on them to be their free employee. But that's what's happening in this case. And so all you can do as an employer is mess up and get in trouble and get fined. You get no benefit from any participation in it. And, when people say that, Connecticut is an unattractive place for business, this is exactly the reason why. I mean, because if you have choices as a business or an industry where you're going to place your operation and where you're going to want to do business, are you going to choose a location where the state government is requiring you to work for them as well as you running your own business? It would be an impediment, and it certainly has proven to be so in our state. I see that as onerous, period. Who would determine through you, Mr. Chairman, to Madam Chairman, who would determine whether or not there's a penalty levied and how it's applied?
Senator Kushner.
That would be the authority, the Paid Family Medical Leave Authority, that we have invested with the responsibility of carrying out this program. And so they would have that responsibility. I do want to say, in response to comments that have been made by some of our members of this committee about the value of this program for people, I actually have heard, not just from individuals who've received the benefit, how wonderful it was and how it really made a difference in the quality of life for them, but also a number of employers, even employers who were skeptical at the beginning. One that I one person who debated me heavily when we were working on this has had both an employee who was losing a parent and needed to take time off to be with that parent. In another case, someone who was having a baby, how this employer did not have the resources to provide funds like this to their employee. And they were so happy that their employee had the backup of this plan. And it really did help. To, certainly I've heard from many that they think it's a very important thing that the state of Connecticut is doing. Thank you for letting me respond to those earlier comments that were made.
Senator Sampson.
Thank you, Madam Chairman. I'm trying to remember the question and the answer that I asked, and I certainly appreciate that you have your own perspective on this. And again, as I noted, I am quite certain we can find plenty of examples that people that benefited from this program. That's not the issue. The fact of the matter is that the state government shouldn't be taking credit for it, for one thing, because it's not all benefit. It is also 0.5% of everyone's paycheck every day, every week, every hour that they work. And nobody that I know came up here and said, I want you to take this money out of my paycheck. The state did it. We just voted and took it. That's all. And maybe it's being used for some good benefit in some places, but that's I think it would be hard not to have some benefit based on the amount of dollars taken and the underlying purpose of the legislation. It's unfair to try and treat it as if it's pure charity and that there is no other costs to this situation. The fact of the matter is there's people in our state that can't afford to buy groceries. They're struggling to pay their rent. I serve on the housing committee. It's something we address every day. The cost of living in Connecticut is astronomical. It's one of the hardest places to live in the whole country as a result. And this is just another cost tacked on. And yes, some people end up getting a benefit that they might have needed only because of the other impediments that are imposed upon them as residents of the state. So I just want to make sure that we're talking about the whole thing and not just part of the thing all the time, because I love the way that these things are spun, that we only hear about the positive aspect of it. None of the TV or radio ads that I've ever heard about this program have discussed the payroll tax part of it. That's ignored like it doesn't even exist. But the fact of the matter is it does exist, and the people who are receiving these benefits and should be aware of it, the same as the people that don't ever collect a single benefit at all from it should know that their money is being taken. That's the right way to do things, so that the people of Connecticut actually can weigh in on whether or not this is a good policy or not. Instead, they're just given a lot of affirmation that only good comes from this program. So that's a kind of an onerous penalty. And the reason why I brought that up is because, let me actually just follow up on that. You said the authority, which I think is so appropriate, as who we're dealing with, the authority. Yeah, and that's what we're dealing with. We're dealing with the government. The government is the ultimate authority. And, things are flipping on their head, ladies and gentlemen, they really are. Nowadays, you kind of have to go to the government to exercise your freedom and ask for permission to do things more and more. And that's completely opposite of the way things ought to be. The assumption is that we're innocent until proven guilty, that you don't need a law to enable you to do things. You can do them if they're not illegal. And we should limit the role of government to simply doing, as I said, protecting people's rights and, making sure that contracts are followed and that there is public safety. That was what was envisioned, not an authority that's going to decide whether or not someone has applied. What does an employer do if they disagree with the authority's determination? Do they have any recourse? How do they say, wait, Mr. Authority, you're wrong? What do I do about that? Who do they go to? How do they end up, could they ever win? And what would the mechanism be? And are there legal fees? Do they have to hire lawyers? Do they have to go through various state agencies to get a fine lifted? Through you, Madam Chairman, or Mr. Chairman.
Senator Kushner.
Just to be clear that since we passed this legislation, the original statute does always say that there are penalties and that the employer is subject to penalties if they fail to remit the required dollars. So it doesn't change the fact that they are responsible for that. What it does do is that it creates a very specific penalty so that people are aware of that and they can identify what they will be responsible for. There is a dispute process if you disagree with the finding that you are that you failed to make the proper payment. So there is a dispute process there. And you give me 1 minute, I'll look it up. So the penalty notice that the employer is provided with when they feel that when it's been determined they've not made the obligated payment, it provides them specific language on how to dispute the penalty. And it is done through an email or by submitting hold on 1 second. I'm looking at the language here. Or they can contact the Paid Family Medical Leave Authority directly. But they're given those instructions when they are notified.
Senator Sampson.
Thank you, Madam Chairman. I appreciate you looking that up. And there are a number of different types of penalties throughout this proposal in the underlying bill and new ones created in the language before us. For instance, in lines 130 to 132, now there's a new penalty for failing to register, for example. But what I asked was, you already indicated that they could be fined by the authority. So I'm asking you, well, okay, so what if you disagree with the authority's determination? I mean, can they put you out of business? Can they I mean, how much power does the authority have to collect this fine? Can they place a lien against your business? What can they do, and what recourse does the business have to fight what they believe is a incorrect fine?
Senator Kushner.
As I stated, they can dispute that through the mechanisms that are laid out by the Paid Family Medical Leave Authority. It should be noted that the vast majority of penalty notices have been waived when the employer complies with their requirement or reports that they didn't have employees on the payroll during the applicable quarter. So there has not been any employer put out of business because of the penalties. Or I think that answers it.
Senator Sampson.
And thank you very much. I appreciate the answer, which was they can appeal based on the terms laid out by the authority. To me, that's not what I'm was hoping to hear. I mean, is there anything in the law that says that they, can go to superior court or any other recourse? I mean, the authority gets to decide whether they're guilty. The authority gets to fine them. And as you noted, you said that, well, there have been very few employers that have been fined after complying. Well, of course, there have been very few fined after they complied. They realized that it was a brick wall. They had no choice. We want to stay in business. We're going to have to comply with whatever the authority tells us. Sounds like a George Orwell novel, the whole thing, to me, to be honest with you, Madam Chairman. What is the recourse that is provided by the authority for a business that wants to dispute a fine?
Senator Kushner.
The issue is that the penalty is for non-compliance. In other words, you have employees and you've not submitted or remitted the payment that is necessary on behalf of those employees. So when there's a failure to do so, then the employer is required to come into compliance. If they fail to come into compliance, they can be penalized. We don't think that there's been a case of this where somebody's gone to court but we're looking into whether or not, if you believed that the authority was wrong, they can I'm told now they can, and anyone aggrieved by any state action can file a complaint in Superior Court.
Senator Sampson.
Thank you very much. Well, that's a relief, Madam Chairman, that they can actually go to Superior Court and pay a lot of lawyers and go fight with the state government and probably lose even if they were justified, and possibly pay more out of pocket for their desire to defend themselves against this authoritarian policy. But I appreciate that at least they do have that recourse. To me, it's unbelievably onerous. You're taking employers that have no interest in being the mechanism to deliver the state's redistribution of wealth slash faux insurance product. And they're doing it for free because they are mandated by and compelled by the state government. And, if there's a problem, they have to go back to that same authority to dispute it. Who's obviously, I've had my own interactions with various state agencies, and they're like the highest court in the land. And going to Superior Court is it sounds well and good, except for the fact that that's an expensive proposition. It ought to be the other way around, where the state should be compelled to have to prove their case in court against the employer. That's the way these laws should be written. Not that it's assumed that the business owner or the person is wrong and that they have to go and defend themselves against the state. And I take exception to that as someone who takes my oath to the constituents that I represent seriously. What's ironic about this is that you go down to Section 4, and there's this part in here about the penalty, who's any person who fails to pay in accordance with the schedule is subject to 1% interest in the amount owed per month. That is like the lightest penalty on earth. Why borrow money from a bank? Just steal it from the Paid Family Leave Authority, because the only penalty is you have to pay it back at 1%. I don't know who's come up with these ideas. So you have the most onerous possible situation against your employer, who is free labor. And in this particular situation, for someone who is actually deprived the fund and potentially other people that are deserving of the money from getting it, their only penalty is that they have to pay it back with a 1% interest. Am I reading that correctly through you, Mr. Chairman?
Senator Kushner.
You are.
Senator Sampson.
Thank you very much, Mr. and Madam Chairman. There's a major disconnect here, why we are being so unbelievably unreasonable in the way we're treating the employer in this situation, who gets zero benefit from this thing. This is nothing but an impediment for them, that they have to process this and potentially become liable for some sort of damages that could be a completely innocent oversight. And yet they might have to pay 10% penalty plus money owed, all determined by the authority. And their only mechanism is a lot of court and lawyers. And in the case of someone who actually is attempting to take money that does not belong to them, and ultimately limiting the resources of the fund, their penalty is 1% per month. Shocking. This disparate treatment is very interesting. As I said from the start, the biggest issue in this thing is the memorandum of understanding. Do we have a copy of what this memorandum of understanding that the governor is working on with the tribes? Do we have any idea what it looks like? Does it have to come back to the legislature for review or an affirmative vote through you, Mr. Chairman?
Senator Kushner.
There is a process by which our governor has been given the ability to enter into memorandums of understanding with federally recognized tribe. It has been employed in the past and created, in one case, a compact with one of our federally recognized tribes. So it is a process, and it has been employed in the past. For instance, I am aware of a time when there was a letter of understanding that was signed with the tribes regarding smoking in the casinos, and Governor Rell signed that letter of understanding at the time. And so there is a process in place. Historically, it's been used before. There is no current memorandum of understanding. If one of the tribes were to elect to opt in to this plan so that their employees could benefit from it, then that would be the time at which there would be a memorandum of understanding drafted. And it is clear that they would have to live up to all of the same requirements as any other employer with regard to participation.
Senator Sampson.
Thank you, Mr. President. Thank you, Madam President, or Madam Chairman, rather. So the answers to my questions are, there is no current document that we can look at. There is no vote after it's drafted by this legislature to affirm it. And effectively what the bill does that is before us is it says that we are going to grant complete carte blanche authority, apparently, to the governor to enter into this memorandum. Do I have that correct?
I would state it somewhat differently. I'm sorry, Manny. I know you were going to call on me. I would state it somewhat differently. Whether or not it has to come before the legislature would be determined by the circumstances. I know in the case of Governor Rell's letter of understanding with the tribes, it did not come back to the legislature, but there could be a different interpretation. My point only is there would not be any memorandum of understanding until one of the tribes initiated that they wanted to participate. And at that time, that memorandum of understanding would be then drafted. Whether or not it comes back to the legislature, that is not clear. That would be really based on, I think there would be a process for determining if that was required. In terms of what would happen with regard to any such letter of understanding, it is very clear that it will have to, the participation in the fund would have to comply with all of the requirements that would otherwise exist for an employer.
Senator Sampson.
Thank you very much, Mr. Chairman. Thank you, Madam Chairman. So whether it has to come back to the legislature for an affirmative vote is a maybe. And I heard you mention the criteria a couple of times, although it didn't seem particularly specific. Is there anyone, maybe the nonpartisan staff can tell us what the criteria is to determine whether or not this will have to come back for a vote, or we're just simply giving the governor the authority to make a deal?
It doesn't have to come back to the legislator under this language.
Senator Sampson.
Thank you very much. My understanding, hearing from the nonpartisan staff, is it does not have to come back, that when we pass this, the governor will be free to develop a document, which we have no idea what it's going to say, and the state will be bound by it. If that doesn't give everybody in the room pause right there, I don't know what does. I mean, are we doing that just because we happen to like the current governor or not? I don't feel comfortable with that. Even people I like, I don't trust them to make deals for me in advance of knowing what the deal is. Are there any restrictions on what can be in the MOU? I mean, I'm reading the language in the bill, and I understand that the memorandum of understanding is for the purpose of authorizing employees of the tribes and tribally owned business to participate in the FMLA quote unquote insurance program. And that any such participation would be governed solely by the memorandum. So does that mean that the governor would be limited into what could be included in this memorandum? Like he can't put some unrelated topic in it? Am I understanding that correctly? And that Conversely, does it also mean that we would no longer be able to write state statute that could govern that relationship?
Senator Kushner.
The intent of this is clear, that the governor and the memorandum of understanding would allow employees of tribal enterprises to participate in this program, and they must participate in the same way as any other employer. And that is the extent of what we are providing the governor the opportunity to do in a memorandum of understanding.
Senator Sampson.
Thank you, Madam Chairman. But what if we don't like what he does? What if he makes a memorandum of understanding with the tribes that says that they only have to put in 0.25% of their payroll checks versus Connecticut citizens that are at 0.5%? What would the recourse of the legislature be at that point if that doesn't have to come back here? Through you, Mr. Chairman.
Senator Kushner.
The intent of this legislation is clear, that the governor would only have authority to enter into a letter of understanding or a memorandum of understanding with the tribes that clearly provides all of the same responsibilities as any other employer in the state. It is up to the tribes whether they want to initiate that memorandum of understanding. But I can tell you from our discussions, they understand their complete sovereignty exists whether or not they want to participate. And they also understand that if they choose to participate, that they will have, that employees of the tribal enterprises will have the same responsibilities as any other employee in the state of Connecticut who's participating in this program.
Senator Sampson.
Thank you, Mr. Chairman. Thank you, Madam Chairman. You said twice the intent of this legislation is clear, and I don't disagree with you. The intent of this legislation is very clear. It is to give the governor supreme authority to negotiate on behalf of our state government in this memorandum of understanding. I don't see anything in the language that limits the terms of that memorandum. I don't see anything that says that he can't enter into a bargain with the tribes. Can you show me language in the bill or have someone else verify that in fact the governor is going to be limited in his ability to negotiate to only include the same terms that apply to state employers and employees? I mean, within the state, not the state employers.
Senator Kushner.
I think that I've been clear that that is the intent of this language of this bill. Obviously, if you feel like it doesn't meet that intent, I've stated it very clearly, and oftentimes we are asked to be on the record and state the intent of language in statute, and I've done that, I think, several times now today, and I'm willing to do it again. But if you think it needs to say something differently, then you can certainly make a proposed amendment. You can do that now, or you can do that at such time as we debate this on the floor of the Senate.
Senator Sampson.
Thank you, Mr. Chairman. Thank you, Madam Chairman. I will certainly continue to do my homework. And I appreciate you trying to lay out legislative intent, although I have zero faith in that. I've watched our courts completely and utterly ignore legislative intent numerous times. And I can provide some examples of that. The most recent one would be the bill on the religious exemption for vaccines, where it was quite clear that students graduating in Connecticut and going to Connecticut colleges would have their exemptions continued, and that didn't happen, despite the fact that it was a question asked and answered in the Senate, and I asked the question and I got the answer as clear as day. Yet when we went to try and litigate that afterwards, it suddenly evaporated into thin air as irrelevant. So I don't have any confidence. No disrespect to you, Madam Chairman. I appreciate you wanting to be as direct and firm on the subject as you can. I just don't see the court ever going back and saying, well, the chairman said so. I don't think that's going to happen. I think they're going to say that we gave the governor the opportunity and authority to negotiate, and he negotiated. End of discussion. And I'm not content, giving him that authority. I don't trust the governor to make this negotiation on the behalf of the citizens of Connecticut. And I certainly don't approve of the idea of giving it to him blindly, which is what we're being asked to do. We're being asked to vote to give the governor blind authority to get into this agreement. I have no idea what he's going to do. I have no idea. That, it's like, imagine entrusting someone to make a negotiation about the sale of your house without ever having any oversight in it. You wouldn't do that. And we shouldn't do it in this bill either. I also think that it's impossible to suggest that the only thing he can determine as the terms of that memorandum would be the same as what we're doing for everybody else, because the tribes are not like everybody else. I mean, I can't come up with a lot of examples off the top of my head, but what about people who are employees of the tribes and also employees of another business in the state of Connecticut paying into the fund? I mean, how are they treated? There's probably dozens of circumstances where you might say that we need to come up with some sort of legislation or at least regulation to navigate the differences between the tribes and the rest of the businesses and employees in the state. And that would not be a simple task, I think. So I guess I'll leave it there on this bill. We covered a lot of things, which is the disparate treatment in the way penalties are applied to employers versus people that are actually effectively abusing the system, who get a slap on the wrist. And actually, I think what is preferential loan terms is what I would refer to it as, versus somebody who's a business who is just going to get slammed even if they're trying to do the right thing. And the situation with granting the governor authority, like same kind of thing. This is what we're doing all the time in this committee and elsewhere in this building, is we are flipping on its head the notion that American citizens are sovereign, free beings who have the right to make and negotiate the terms of their own lives. And we're taking that away from them by empowering the government to make decisions on their behalf. And we're also taking away the right of their representatives in this particular case. Each one of us has the right to debate and vote on the policy that we're talking about here. And we are going to surrender some of that to the governor to make this negotiation. And I'm not in favor of that. I want to make sure that I'm looking out for my constituents. So I'll be a no today, Mr. Chairman. Thank you.
Thank you, Senator. Any further discussion? Representative Weir.
Thank you, Mr. Chair. My colleagues did a great job of covering the finer points of the bill and the details. And thank you and Senator Kushner for going through in detail of what the bill does. I would just like to illustrate a point that I have work for small employer or employer, and that employer has a paid family medical plan. Right, there's paid time off, there's sick time, vacation time, and there is a long-term plan as well. Yet every week or bi-weekly, my wages are deducted 0.5% for the Connecticut paid family medical leave, which is a fact that I resent. And I think if more people understood that, how it works, they probably would resent it as well. And I guess if I were to go to use the benefits of one plan or another, the way this plan is written, never mind the new language, which again further tightens down the restricts the usage, restricts people further. I would have to use my employer's plan before I could exercise any of the benefits of the state plan. That's just the way it's written. I could not go to the state first. I'd have to go to my employer, use that time up first before then applying to the paid family medical leave. And I'll just, we heard people come in here, workers of all kind, talk about the term wage theft. And if this isn't wage theft, where you're paying into something that you do not have the ability to use as a first resort, it's a last resort, if at all, then that's what I want to liken this to. The whole thing, as I've said, is I believe it's a house of cards. We don't have full utilization. I'll just leave it there, and thank you for indulging.
Thank you, Representative. Any further discussion on
Chairman.
Senator Kushner? So,
I do want to make a correction, Representative Weir. An employer is allowed to grant an employee the ability to go to the fund before using or utilizing any other employer program or paid time off. The reason why it is not an option of the employee, and this is something that was insisted upon by some of our major businesses during the negotiations of this first bill, is also true for the Family Medical Leave Act. That is a federal bill. The bill is written in the same way that employers can allow people unpaid time off without first using all of their employee benefits, but it is not required by an employer to do so. This is a piece of the legislation that I would have preferred differently, that it was entirely up to the employee whether they use this benefit before using any paid time off from the employer. Unfortunately, our employers in the state of Connecticut lobbied heavily against it, and we were not able to accomplish that. So I just want to be clear for the record that this is an employer demand, not something that the state of Connecticut put on them. And I agree with you. I think it would be much better if an employee could decide whether they want to use their paid time off from their employer first or use the program first. So I don't like that part of the law either, but it was where we had to go and when we passed this original statute.
thank you, Senator Kushner. Representative Weir?
Thank you, Senator Kushner. And I guess the differentiation that I draw is that with my employer, the employer is providing those benefits one way or the other. And in this case, I'm providing them for myself, but I can't access them. So regardless of the process, I'm disappointed in how it is. And that's it. I'm paying into something that I can't use because of the process, but thank you.
Thank you, Representative. Any further discussion?
And I totally agree with you, Representative Weir. It's disappointing that that's the way this bill was written because of the employer input on it. Thank you.
Thank you, Senator. Representative Wilson?
Just a brief statement. You know, I think for me, where my district lies, I'm close in proximity to both of our tribal nations. And we have a fair amount, thousands of workers that work for both of these amazing tribal nations that would benefit heavily from this opportunity. You know, I think when an individual works hard to put into the economy and continue to help business and a company to build this success, I think both tribal nations are on board to do what's best for their employees, but also uphold their piece of this bargain. And so I have the faith that, you know, we'll do what's right and making sure that everyone gets a fair shake in this. But, you know, I have thousands of individuals down in my area that would greatly appreciate the opportunity for being able to utilize paid family to take care of not only loved ones, but also childbirth and so on and so much more. That would really be a transformative thing for many individuals. So thank you.
Thank you, Representative. Any further discussion? Ms. Clerk, please call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 3, Senate Bill 222, an act concerning changes to the paid family and medical leave statutes. The motion is to JFS this bill to the floor, and the relevant LCO is 2702. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Senator Cabrera, Representative Wilson,
Representative Wilson votes yes.
Senator Sampson,
Sampson is no.
Representative Weir,
Rep Weir is no.
Representative Ackert,
Rep. Ackert, no.
Representative Belton,
Belton votes yes.
Representative Hall, Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Yakarino.
Representative Yakarino votes no.
Thank you, Mr. Chairman.
Thank you, Mr. Clerk. Motion to JF to the floor, item 4, SB 223, an act concerning workers' compensation.
So moved.
Seconded, Rep. Hughes.
So moved by Representative Wilson, seconded by Representative Hughes. This bill requires the Workers' Compensation Commission to study workers' compensation system and report to the Labor Committee by January 1st, 2025. Any discussion? This is workers' compensation. Yes, sir. Any discussion? Senator Sampson,
Mr. Chairman, I'll just ask, can we confirm that this is another placeholder bill?
that is correct, sir.
Yeah, I'll just say for the record, go back and rewind to the last commentary I made on the previous placeholder bill. I will be a no today on this placeholder for the same reasons and all the other ones as well.
Thank you, Senator. Any further discussion? Mr. Clerk, please call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 4, Senate Bill 223, an act concerning workers' compensation. The motion is to JF this bill to the floor. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Senator Cabrera, Representative Wilson,
Representative Wilson votes yes.
Senator Sampson,
Sampson is no.
Representative Weir,
Rep. Weir is no.
Representative Ackert,
Rep. Ackert, no.
Representative Belton,
Belton's yes.
Representative Hall, Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Yakarino.
Representative Yakarino votes no.
Thank you, Mr. Chairman.
Thank you, Mr. Clerk. Votes will be held open. Motioned to JFS to the floor, item 5, an act concerning unemployment benefits, LCO 2618. So moved by
Seconded,
Representative
Rep.
Wilson,
Hughes.
seconded by Representative Hughes. This is for labor disputes that start on or after December 14th, 2025. This bill generally makes striking workers eligible for unemployment benefits after they have been on strike for 14 consecutive days. Current law generally disqualifies claimants for benefits in their unemployment is due to a labor dispute unless it is a lockout or they are non-union employees at a business temporarily closed by the strike. The S language in SCO 2618 applies to labor disputes that start on or after December 14th rather than December 15th, 2025. Discussion. Representative Ackert.
Thank you, Mr. Chair. So I want to start with, when they go on unemployment, if we don't want that to happen, that's the case. We just don't want anybody to, we don't want to go on strike, never mind going on unemployment. But obviously if that takes place and it draws out, they just cannot come up with an agreement. And then if this legislation moves forward, they could apply for unemployment. And granted, it's not a windfall when you get unemployment, but it's could be a bargaining factor. Oh, hey, we're close to the 14 days. Stick it out. They're going to come to their consensus. Because my concern is one piece of this is that who is in it, let's say it gets to 14 days and then they go on unemployment. Is it the companies? There's experience when you have to lay somebody off, which unfortunately, decades ago I had to lay somebody off, and you then have to, your experience gets increased on what you have to contribute. So would it be that company's experience that's affected if they do go on strike? To you, Mr. Chair or Madam Chair?
Thank you, Representative. Senator Kushner.
I believe that's the case, but if you want to give me a minute, I will make sure of that answer. But I do believe it would impact the employer's experience rating. Yes, that is correct.
Thank you, Madam Chair. Appreciate that. So that, that's a, another unintended consequence, maybe help make the employer come to the table. So that's kind of way, my concern is it kind of weighs a little bit more in the favor of the worker in that case. I'll continue to listen to the dialogue. I did have a productive meeting with some supporters of this to bring their concerns to me, and I do appreciate that. But I'll listen to more of the dialogue. But that's one of the couple concerns that I have with this legislation. So again, thank you, Mr. Chairman.
Thank you, Representative. Any further discussion? Representative Weir.
Thank you, Mr. Chairman. And we heard this concept last year and certainly met and discussed this with some of the proponents. We've heard a lot of testimony from workers who could potentially be affected by a strike if they were to go out on strike. We heard examples from workers historically who either had gone out on strike or who had family members. Some recounted a father or a mother who went out on strike and it took an act of courage, I suppose, on their part to to bargain for what they believed in. Language on the bill is pretty straightforward. I don't have a ton of questions on it, but I think the concept is something that we're going to talk about here today. And I want to point out that I do recognize I was sympathetic to listen to those employees who talked about, I'm a single mom, and I made the decision to stand by my union co-workers, brothers and sisters, as they were called, and it took an act of courage, and I don't disagree with that. I think the difference here is at this point, we're being asked to consider whether or not we're going to take a side with one side or the other. And philosophically, I don't believe that this body has any business interfering between the two parties. That you have a management, the company per se, and you've got the employees and labor, and ideally they're working harmoniously together to provide a service or a product that gets delivered to all of us. And this happens every day. It's automobiles, it's food, it's healthcare. And when there's a dispute, you've got the labor and management have to come together. They have to come together and work it out. And eventually it does get worked out. Obviously, you would hope that that would get worked out as soon as possible, that both sides would come to the table, bargain in good faith. The employees, of course, have the right to bargain for their best interests, as does the employer. And so I just wanted to wanted to dive a little bit deep into this as to how I see this and how I think the rest of us should be looking at this. A strike is very disruptive. We had employers come in, we had union representatives come in, we had employees come in and talk about how disruptive a strike is to everybody. So for the employees, you've got lost wages. In some cases, people talked about not being able to pay their rent, having to go to their landlord, having to borrow money to get through that period of time. Lack of security, extremely stressful. Some people were not able to talk about Christmas gifts, not being able to provide Christmas gifts for their kids during that time, but they felt that the end result was going to be worth that time. And in some cases, some of the people admitted, and I don't say admitted, they testified to the fact, and I'm not judging, that they, whether or not they agreed with the strike, they felt that they owed it to their union co-workers to stand beside them. And they have every right, and I commend that teamwork and working together to achieve a common goal. I have no issue with that. Then we take a look at the employer side of things. So I've not, tried to make the case that it's disruptive and stressful for the employees. And then on the employer side, you've got work stoppage You've got bills that are continuing to pile up, just like the employees. The cost to the employer is equally immense as and damaging as it is to the employee. You've got a potentially that employer has to consider hiring replacement workers, potentially looking at even going out of business. And there are examples of employers and businesses that have claimed bankruptcy and gone insolvent as a result of a work stoppage and a strike that couldn't be resolved. There's evidence out there of that. So I think a strike at the end of the day is it's scorched earth. It is the absolute method of last resort. And we did have employees testifying. We had union members come in here and testify that it is the absolute last resort. Nobody wants to go on strike. They want to continue to work. They want to bargain in good faith and be paid what they're worth. And I absolutely agree with that. I think what we're looking at here is the difference is that we're being asked to ask the employer to provide a benefit. Although, my colleague here, said it, look, it's not a windfall, right? This is it's not a full pay. But at the end of the day, unemployment compensation insurance is paid for by the employer. So this body, by doing this, we are by no means staying neutral. We are tipping the scales on the behalf of the employee, whether it be to what percentage, to what level, I can't tell you that. We are tipping the scales by getting involved and saying that at the point of 2 weeks, which is the proposal here, that the workers would be able to file for unemployment compensation insurance paid for by the employer. So I get it that when, as a last resort, both sides walk away from the table, and that's how a strike occurs, when there's nothing else to be gained through bargaining. But I don't think that that's our job to step in and say to the employer, now you're going to be paying for your employees. And it was stated that, it was stated in early testimony by more than one person that it is, we want to get back to work. We don't want to go on strike, but we want to force the employer to come to the table. And that resonated with me when you're using the word force, because at that point, it's not willful or it's not mutual, force. And so we're being asked to assist one side with forcing the other side to behave in a certain manner. While we were sitting here, I looked up the U.S. Department of Labor describes that they define a strike as a temporary work stoppage by workers to support their demands on an employer. So it's a work stoppage by the workers to support their demands on an employer. And I'll say again, they have every right to do so, but it is not our job here to potentially put extra force on an employer to provide benefits to allow the employees to hold out longer. It does not, that doesn't compute with me. Mr. Chair or Madam Chair, can you tell me, in Connecticut, are our public employees allowed to go on strike?
Senator Kushner.
They're not.
Could you repeat? Couldn't hear you.
I'm sorry, I said they are not.
They are not. So in here, we recognize the right to collectively bargain. State employees, we recognize municipal employees' right to collectively bargain, but they're not allowed to go out on strike. And yet here, in this piece of legislation, we're looking to go to the private sector, and where we recognize again that employees have the absolute right to collectively bargain and they have the right to strike. And everybody nobody testified that a strike was a pleasant thing. But I can't see why in this state, if we don't even allow our public employees to strike, why we're going to take a side and not only, well, it's permitted, why we would take a side and encourage, in some cases, I mean, there were people who said that the data would show I didn't see the data, but the data would show that strikes are no more likely if in the states where this legislation is passed and where the employer is required to pay for the unemployment compensation insurance. So why would we grant, I guess it's another impediment to doing business in Connecticut when whether or not it actually does affect the outcome of a strike, we're sending the message that that we should be inputting ourselves between the two parties. I guess just one question on the bill, and that was really in around that new JFS language. Why are we making this effective December of 2025 versus, if this is such a, it's an important matter, and we were, lots of people showed up to testify. Why are we pushing this out more than a year, Madam Chair or Mr. Chair?
Senator Kushner.
We are pushing it out because, as you probably know, we are part of a compact with other states in terms of the system we have now for our unemployment insurance. And so to make the changes that are necessary in the system, DOL would prefer that we push it out so they can implement the change. I also want to say a couple of things about the definition. First of all, that you wrote about a strike entails work stoppage in order for workers to have an employer meet their demands. It is actually most common, and I'm sure there are definitions that would say this, but it is most common that strikes occur when an employer has made demands on the employees, like demanding that they give up their health insurance or give up their retirement benefits, that it is most common that a strike occurs when the employees feel they cannot meet the demands of the employer. The other thing I want to mention about public sector employees that you asked about, that they don't have the right to strike. Federal law does, and the laws pertaining to strikes pertain only to private employers under federal law. And every state is allowed to determine whether or not they provide laws that allow state or public sector employees to engage in collective bargaining to begin with. In our state, we have a system that allows for binding arbitration as opposed to a strike. And I think it's worked out to be a good process. And I know that there are many times in my own experience where we couldn't reach agreement with an employer. We offered to go to binding arbitration as an alternative to a strike. Unfortunately, in my experience, an employer never agreed to that. So we didn't have that as another way to resolve the dispute. But that is something that I think is positive in our state labor laws, and sometimes would work well if there was an agreement in the private sector to do so as well. Thank you, Mr. Chair.
Thank you, Senator. Representative Weir.
Thank you. And Madam Chair, I appreciate your definition of a strike. I'm just using the U.S. Department of Labor. That seemed to me to be a credible source, and that was the language that I used. Nothing around it was initiated by the workers, according to the U.S. Department of Labor. I would like to point out that we did hear from some people who were testifying, talking about the presence or absence of a strike fund. And for the people out there listening, a strike fund, as I understand it, is a fund maintained by the union to, in some cases, some unions maintain them, some don't. I learned through this process that there's no requirement for the union to maintain a certain amount of money. They vary. Some can cover employee costs for a short period of time. Some admitted that or testified that there was nothing or almost nothing. And so I would say You know, us asking the employer to pick up the tab by way of unemployment compensation would be the same as me sitting up here and saying that we need to mandate that an employee union maintains a strike fund adequate to maintain the employees' living expenses during the duration of a strike. And I think if I brought that amendment up here right now, I'm pretty sure that we would have, people would be outraged, because here, I'm sitting up here. First of all, it would be a mandate, which, you know, I'm not going to go for. Second of all, I'd be picking a side. I'd be up here saying that I'm siding with the employer. And that's not my job up here to do. And that's not our job up here to do. Our job is to protect the rights of the citizens of Connecticut. And that's it. I do not see us, I look at this as us tipping the scales, the balance of power in a relationship. And that's not our job. You have in a perfect world, the employees and labor get together with the company, the employer and management, and they work it out. And eventually they do in most cases. And I agree. We heard the stories. It's not a pleasant process. When they hit that, when the employees go out on strike, it's the absolute nuclear button. And it affects the employees, it affects the employer, it affects the customers. I mean, there are ripples down the supply chain. Subcontractors, I'm sure, suppliers, customers. Many of us are affected when there's a strike. Some more than others, for sure. I mean, customers have the choice to go shop elsewhere. And if they do, what's the chance that they go back to that employer when the workers return to work? What's the chances if those employees go on strike and the customers go elsewhere and the suppliers find another person to hire them? How do you recover that work? And if the employer doesn't have the work, then the employees certainly don't have the work. So I recognize the risks that the employees take. I don't take it lightly. I heard all of the testimony. I listened to it all. It was heartfelt. For the most part, every bit that I could tell was sincere. But I think asking us to weigh in, to put our thumb on the scale of one side of an argument or a disagreement is wrong. So I think I'll leave it there, Mr. Chair, Madam Chair. I'll allow my colleagues and I just make sure I got everything, and I appreciate the time.
Thank you, Representative. Any further discussion? Representative Yakarita.
Thank you, Mr. Chair. I'm definitely sympathetic to the workers, but also the employers. But listening to this and putting the burden, both are unburdened for striking, the workers and the employer. Either they're gonna lose a lot of money. There's angst and stress. But if we're gonna levy the unemployment, the state should pick up that tab. The employer should not pick up that tab for the expiring rate. If we want this, the state should pick up the tab. Even that's wrong, though. That's actually fundamentally wrong, because we're picking winners and losers. And I'm sympathetic to workers. I've worked very hard in my life through labor's jobs. A lot of my friends are in the trades. The fact is, to Representative Weir's point, there should be an unemployment fund that is picked up by the companies. I mean, by the unions. You know, you do pay union dues. I was in a union years ago. Yeah, I paid dues. I pay those for a reason. So saying that, I'm sympathetic, but I think we're picking winners and losers all too often. And so again, I'm sympathetic, but you have to look at the holistic view and the whole overall picture. I think state wants to do it, they should mandate it. Even then it's wrong. Thank you.
Thank you, Representative. Senator Sampson.
Thank you, Mr. Chairman. This is not the first time we've had this bill. We've had it a number of times before, and we had a lengthy debate in the Senate a couple of years ago that went for several hours, and I'm certainly prepared to do that again. But I will save everyone that today, and I'll try and keep my remarks brief. But I will make it very clear that I don't like this bill at all, and if it does come to the Senate, I'm going to do what I can to prevent it from advancing into law. And as other folks have said, I mean, I'm certainly sympathetic to the people that came before the committee, but they're being sold a bill of goods. I'm going to quote Joe Biden, something I never done before, and say, "Come on, man! This bill is ridiculous. It's patently ridiculous on its face. Anyone who actually looks at this and says that this is like a rational public policy needs to have their head examined. Okay, I mean, the fact of the matter is a dispute between employers and employees is between them. The fact that employees can collectively bargain already is a tremendous advantage in the favor of the employees. They can effectively block a business from operating. I mean, that's pretty good. Because employees have a lot more options than the employer does at that point. I mean, what's somebody do if they own a company? They're not going to go run a different company the next day, but the employee could go get a different job if they needed to. So the idea that there's some sort of level playing field situation that either exists or is attempting to be created by this bill is just, it's madness. The state government has no compelling interest to get involved in this. Every interest that I could point to is actually contrary to the benefit to the people of the state and to the state government. So it really surprises me. And it's like a repeat of one of the common frustrations I have in this particular committee, which is that almost every bill is designed to go ahead and pit employers versus employees. And I'm tired of it. Honestly, and Mr. Chairman, it's like, why do we keep doing bills like this? Why don't we start coming up with policy that benefits everybody involved? Why don't we try and come up with policy that gets government out of the way of people going out and making a better life for themselves? That's what we should be doing. We should be using the Labor Committee to develop policy that is devoted to improving the potential upside for people and businesses in the state of Connecticut by removing impediments from the creation of jobs and high-paying jobs at that. That's what we should be doing. But instead, this is just again. I go back to the first level arguments are what is the industry going to feel about this bill? Well, Connecticut, another dangerous provision to do business in Connecticut. Let's move our company to Massachusetts or New Jersey or somewhere else. That's number one. What happens to employees in a case like that? Where do the employees go when the employer says, well, Connecticut's not a good place to do business because they enacted yet another overreaching policy? The employees suffer too. Are we forgetting that? I'm not forgetting that. I hate being tagged because of the people that generally follow this committee are overwhelmingly pro-labor, as if somehow I'm anti-labor. That's ridiculous. I'm not a company owner. I'm not making a fortune from my company friends. I'm a worker like everybody else. But I do believe in fairness. And I mean that legitimately, not as a political term. That's the way the word fairness is used in this building, as some sort of political mystery term. Fairness is when you don't give one side of a dispute an advantage over the other one. And that's precisely what this bill does, as has been pointed out by my colleagues. And in this particular case, I would say that this advantage is absurd. It's absolutely absurd. A strike, as was pointed out, is like a nuclear option for both parties. The employer obviously wants to keep their operation running. They certainly do not want to lose their employees, even temporarily. So they want to make sure that they're happy, that there's good morale, that they're focused on doing their jobs and making the company more successful. That's what they care about. So why would they want to make a strike or prolong it? Of course they don't. So when a strike inevitably occurs, it's not just because the employees have had enough and are fed up and like can't stand the working conditions. It's also because the employer is like, I can't give you any more. That's when a strike occurs, when both sides can't budge anymore. But what this bill does is says, well, now that we've got one side of that equation stretched so thin, if we give advantage to the other side, then they'll have to move. And that's what this is about. This committee was not created to replace the ability of collective bargaining to occur. But that's what this bill does. The unions ought to be the ones negotiating the terms of the contracts with the employer, not us sitting here on this panel deciding that we're going to give an advantage to one side or the other. And I don't like seeing this committee used over and over and over again to put things into law that ought to be negotiated. This bill is like a complete opposite of fairness. It also ignores lots of elements of reality. I mean, what are the requirements to collect unemployment, for example? Mr. Chairman, maybe you can answer that question, or Madam Chairman. Normally, what do you have to do to be able to be eligible to collect unemployment?
Senator Kushner?
Normally, you have to not be working.
Senator Sampson, I apologize.
I appreciate that answer, and I don't want to be disrespectful, Madam Chairman, but for the chairman of the Labor Committee to give me that as an answer is unfortunate. I mean, seriously. The requirements that you have to be unemployed through no fault of your own, you have to be available to work, and you have to be actively seeking another job. Those are the requirements in Connecticut, and everybody on this committee should know that. That should be like, if you shouldn't be allowed to serve on this committee unless you know that. It's a basic premise of our existing law. But this law says, forget all that, because we're going to give these benefits to folks who are not unemployed through no fault of their own because they're making an active choice to not be employed. We're also going to give unemployment benefits to people that are not available to work because they're saying, I'm not going to. And we're also going to give it to them for the very third reason. All three reasons, all three that are required for everybody else to get unemployment, out the window with this. You have to be seeking another job. Instead, we're going to take a benefit intended for people that are actually in an unfortunate circumstance of not their own making to cover them temporarily so they can get by. And we're going to use that. We're going to use that as a way to force one side of a negotiation into submission. It would be completely wrong if it was the opposite way, just the same. If we were up here working on legislation that said that while the strike was being negotiated, you had to go to work unpaid, that would be insane, wouldn't it? Anyone want to take that question? It would be insane to expect that of the employee. So why isn't it equally insane to suggest that the employer, when his employees walk off the job and say, I'm not going to work, to be in a position to not only lose their labor and the functioning of their business, to have to pay them something, in this case, in the form of unemployment compensation. It's absurd. I go back to Joe Biden. Come on, man. I am more than happy to sit here and work with my colleagues to come up with ways to improve the protections for employees in this state. But this is not a protection. This is an absurdity. And the fact that it's back, for like 3-4 years in a row is not making it more legitimate in my mind. I know that's how this place works sometimes. We just keep coming back with these crazy ideas. Senator Looney came before the committee, I think it was last year, and said that the employer should pay their health insurance for their employees that are on strike too. And I guarantee you, if this becomes law, that'll be next. I mean, should the employer continue to pay their employees, indefinitely, give them their wages, their unemployment, and their health insurance too? I mean, where does it end? And the nerve to talk about fairness. Think about our unemployment trust fund in the state of Connecticut, by the way. I think our unemployment trust fund went bankrupt during the pandemic. We had to borrow billions of dollars from the federal government to stay afloat, to take care of people that actually needed their unemployment benefits for not for losing work through no fault of their own, being able to work and actively seeking for work to take care of those people. We're still paying it off. And employers in this state pay some of the highest rates in the whole country. I don't know, we may even be the highest. It wouldn't surprise me at all to find out we're paying the highest unemployment compensation, funds for employers. Not to mention all of the ancillary things that can happen too. I mean, if municipal employees go on strike, or people that are contracted with municipalities go on strike, and the costs, that ultimately inevitably end up being borne by towns, by the state, they all get passed on to taxpayers. It's the taxpayers that end up paying for everything. And for what? So that you can give an extreme advantage to one side of a labor dispute? It's not fair. And look, I challenge anyone who's on the other side of this issue to come and debate me publicly, one-on-one, in front of some actual real members of the public who actually pay taxes. And to convince them that it's fair. It's not fair. It's just not. I got lots of people in my friends and family that are parts of labor unions. When I brought this to them, and again, I'm not even going to say whether they're for it or against it, but they said it was crazy because they recognize what's going on here, which is we're perverting the use of this labor committee in the state government to inject ourselves into something the state's got no business doing, which is participating in assisting one side of a conflict that's happening in the private sector. That is not the role of government. And I will continue to resent the fact that I'm forever put in this position of being pointed out as being, for or against employers and employees. That's not how I come to work every day. I come here trying to make good public policy for every person, regardless of the situation. And I take fairness as a serious thing, going back to the way our country was founded with the notion that people should be treated equally under our laws. This bill will not treat people equally under our laws. It will take sides in a dispute. It's something that shouldn't happen. Again, Mr. Chairman, I could really, this is the kind of bill that could generate a lot of conversation, but I will let it go for today and reserve my my thoughts for the Senate floor, where I hope it doesn't get to, because I know that the governor has been tagged on this subject a number of times, and I think his most recent comment was that he was suspicious of it or something to that nature. I may be misquoting him. I don't mean to. I just don't remember his exact term, but he certainly was not convinced that this is a good policy, and he shouldn't be. I would encourage him to take a look at it. I don't think it's good for Connecticut. Thank you, Mr. Chairman.
Thank you, Senator. Any further discussion? Seeing none, Mr. Clerk, the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 5, House Bill 5164, an act concerning unemployment benefits. The motion is to JFS this to the floor, and the LCO is 2618. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Senator Cabrera, Representative Wilson,
Representative Wilson votes yes.
Senator Sampson, Representative Weir,
Rep. Weir is no.
Representative Ackert,
Rep. Ackert is no.
Representative Belton,
Belton votes yes.
Representative Hall, Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Yakarino.
Yakarino is no.
Thank you, Mr. Chairman.
Thank you. Votes will be held open. On to the next item, motion to JFS to the floor, item 6, HB 5165, an act expanding Connecticut family and medical leave benefits to non-certified school employees, LCO 2406. So moved, Representative Wilson,
Seconded, Rep. Hughes.
seconded by Representative Hughes.
This bill reduces the number of work hours non-certified school employees need to qualify for unpaid family and medical leave. Discussion? Representative Weir.
Yes, thank you, Mr. Chair. Can you please get the JFS language here? What's materially different from the paper that I had my notes on to what we were handed today?
Okay, thank you, and I apologize. I should have stated that. The LCO language removes language in the original bill that made the organ and bone marrow provision apply to an employees who are in a same-sex marriage.
All right, thank you. I think, we looked at please correct my memory on this. This came through this committee last year, passed out of committee, and then what happened with it from there?
Believe it was referred to education, and it didn't move forward after that.
Thank you. I don't think I have anything further on this. I recall the conversation on that, so thank you.
Thank you, Representative. Any further discussion? Seeing none, Mr. Clerk, please call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 6, House Bill 5165, an act expanding Connecticut family and medical leave benefits to non-certified school employees. The motion is to JFS to the floor, and the relevant LCO is 2406. Senator Kushner.
Senator Kushner votes yes.
Representative Sanchez.
Representative Sanchez votes yes.
Senator Cabrera. Representative Wilson.
Representative Wilson votes yes.
Senator Sampson.
Sampson is yes.
Representative Weir.
Rep Weir is yes.
Representative Ackert. Representative Belton.
Belton votes yes.
Representative Hall. Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Yakarino.
Yakarino is yes.
Thank you, Mr. Chairman.
Thank you, Mr. Clerk. Next item, I'd like to motion to JF to the floor, item 7, HB 5264, an act concerning volunteer department and ambulance companies and the definition of employer under State Occupational Safety and Health Act. So moved, Representative Wilson,
Seconded, Rep. Hughes.
seconded by Representative Hughes. This bill requires a volunteer fire department or volunteer ambulance company to comply with the state's Occupational Safety and Health Act, Con OSHA, as an employer unless it is regulated by the federal OSHA law. By law, Con OSHA governs workplace safety for the state and its political subdivisions as employers, but certain non-governmental volunteer fire and ambulance companies are not considered employers under this current jurisdiction. Discussion? What? Okay. Sure. Senator Sampson.
Thank you, Mr. Chairman. Can you just explain what the purpose of this bill is? I understood what was described, but can you tell me, how this came up and why we're looking to enact this requirement that Connecticut OSHA is going to take over this responsibility?
Senator Kushner.
Yes, it is clear from the way the federal law is written that it is only has determined that these laws would apply to employers. And since it's a volunteer company, it would not automatically come under the federal law. However, states are allowed to enact their own occupational safety and health acts that would go beyond where the federal government is. In this case, we are saying that in the case of a volunteer fire department or ambulance company, we want to make sure that they still have access to all of the benefits and requirements that the state places on organizations to make sure that they're safe. So there are things that these volunteer companies would have access to, like trainings and like inspections so that they can be certain that equipment that they're using is within the guidelines of the state sets for what is safe in these particular instances. So there was a case, I'm sure you're aware of, many years ago where Con OSHA came in to a volunteer fire department and found that something was not done in accordance with state requirements for safety, and that entity took them to court. And because it was not clarified in our law, and certainly wasn't covered under federal law, it was found to be that Con OSHA could not be enforced in that situation. So this is basically cleaning up a loophole that I think was not intended by, or it's an important loophole that I think our state needs to address.
Senator Sampson.
Thank you for that answer, Madam Chairman. I'm just, reading the testimony, and I know this bill has been before this committee, I don't know how many years before I got here. This bill has been coming here and failing to pass every year. And each year I notice that the local small town volunteer fire departments are in opposition. And generally speaking, when I hear that, I'm on their side, and I could really use some convincing. I voted against this bill each year in the past because from their perspective, I think that they are concerned of having yet another level of bureaucracy overseeing what they do. I've never read the Supreme Court case, but they point to a Supreme Court decision that concluded that volunteer fire departments and ambulance companies are private employers and that they don't fall under the jurisdiction of Connecticut's OSHA laws, which I presume, which is why this bill is here. But I don't blame them for not wanting to have yet another mountain of red tape, invoked in their activities. Do you have any compelling reason to suggest that what they're doing now is inadequate and why they need to have this bill passed? I mean, what is the benefit of this bill to the citizens of Connecticut?
Senator Kushner.
I think it's really important to the people of Connecticut that when we have small towns, or even in some larger towns and cities, there are volunteer firefighters, volunteer ambulance companies, and I think that it is a benefit to the citizens of Connecticut that we are assured that they've been under the jurisdiction of our occupational safety and health laws and requirements, so that we're sure that not only, we want to ensure that the people who are attending to fires and attending to emergencies, we want to make sure they are safe, but also if they are not operating within the law, in fact, it could be a danger to the citizens. If a person doesn't know how to properly fight a fire, it could be a danger to the citizens. I don't believe we had, if we had any testimony at all this time in opposition, I don't recall it. There might have been one or two, but in fact, we have hundreds of volunteer firefighting companies and ambulance companies in the state. I know that when we first discussed this, I went specifically to the ones in my district and asked about this, and I had I really didn't, they were happy to be covered by Con OSHA. They saw it as a benefit where they would get training and they would have inspections to ensure that the people who were volunteering were safe. It is clear that we require Con OSHA in the career firefighting departments and the ambulance companies that work within our cities that are career, or where there are paid employees. And I don't know why we would want in this sector where it's volunteer, we would want any less, because we obviously as a state feel like it's really important that these particularly in the case of fighting fires, that they're done safely. So I would encourage our members, I know there was a dispute with one small town, but I would encourage our members to consider the importance to the citizens of Connecticut and in this case, and hopefully we can come together and get this done this year.
Senator Sampson.
Thank you, Mr. Chairman. Thank you, Madam Chairman. Just for the record, I'll let you know that there are 10 pieces of testimony that were submitted. 9 of them are in opposition. Among the 9 pieces of opposition testimony are the first selectman of Griswold, the first selectman of the town of Canterbury, the first selectman of the town of Eastford, the first selectman of the town of Goshen, the executive director of costs, Betsy Guerra, and a couple of other folks, including the fire chief for the Goshen Fire Company. I would trust the fire chief from the Goshen Fire Company on the fact that he wants to keep people safe. And I heard you say it was important for the safety of Connecticut, but I haven't heard an example yet of something that has happened or could happen that might be a factor to compel me or anyone else to support this legislation. I'm relying on the people on the ground and the towns that are impacted and the actual volunteer fire companies that are impacted. And again, I don't think you become a fire chief by not being interested in public safety. So, I mean, it's hard for me to second guess them on that subject. So, Madam Chairman, I'll ask again. I know you said it's very important for public safety. I got that, but can we have something more specific? Like, why is this necessary? What exactly is going to change that will protect the citizens of Connecticut?
Senator Kushner.
So I stand corrected on testimony that was submitted in writing after the hearing. So I recognize that you are correct in that. But I will stand by what I said, that there are hundreds of volunteer firefighter companies and ambulance companies that did not testify. And I can only state my own experience talking to people in my district. In terms of any specifics, I think I've been clear. There are training opportunities that we make sure that ConOSHA, part of the regulations are to inspect equipment. And I believe that is beneficial to our citizenry and would prevent any unintended consequences. I don't doubt that the fire chiefs that you referenced in your statement care about the safety. I just think that in this case, we can do better. Thank you.
Senator Sampson.
Thank you, Mr. Chairman. Thank you, Madam Chairman. Yeah, I mean, I certainly expect that different volunteer fire departments have their own training standards. They have certifications. They go through a lot of things to make sure that they are up to snuff. And obviously they are in the business of public safety. And I appreciate you trying to come up with an answer for me, but repeating that we think we could do better and stuff like that is not rising to the level of convincing me, particularly since the only in favor testimony that I see here, and I do love your argument that, there's lots of people that didn't testify that are on the other side. I'm going to use that going forward. I promise you. When the testimony doesn't go my way, I'll be certain to point out that there's hundreds of people out there that agree with me. But the only testimony in favor is from the labor commissioner. And clearly, because they want to have more control over the situation, which is what governments crave. So I'm not convinced, Madam Chairman, yet again. I figured this year I would try and give a reasonable chance to be convinced that this is a good policy, but I'm not seeing it. I trust these small towns and their local fire companies to make good decisions. I don't think they need ConOSHA to intervene. Thank you.
Thank you, Senator. Senator Kushner.
I do want to suggest that it would be wise. I'm sorry. I know I was muted for a moment. I think it would be wise for all of us to look at the records that DOL has on this. I believe the reason why the commissioner has brought it to our attention is because of complaints that have been filed with DOL that they cannot respond to, given the fact that we have not closed this loophole. My understanding is there have been 37 complaints in the last 8 years. I think we're fortunate, we don't hear about fires too often in our small towns, and that's a good thing. But of course, the fact that in 8 years there's been 37 complaints, I think it's worthy of our attention. And I know I intend to look further into those. But for today, I'd like to keep this bill moving forward because safety is critically important. And I know, Senator Sampson, you don't appreciate those platitudes, but they're certainly how I feel. Thank you.
Thank you, Senator. Any further discussion? Representative Weir.
Thank you, Mr. Chair and Madam Chair. I read the written testimony as well. Many of the opponents, again, this, as my colleague Senator Sampson pointed out, 9 opposed, 1 in favor, and many of them referenced that they have safety programs in place already, that this would be an additional burden, cumbersome, and in a couple places referred to this as an unfunded mandate. So for today, I'm a no. And what I'm going to do, I know I covered this topic last year with my fire chiefs in some cases. I'm going to go back through my district and check with our fire departments to see how they feel and weigh in, and maybe I can be swayed. But for today, I'm a no, given the testimony that we see here talking about mandates, additional costs to towns, additional burdens, all things that are just that are warning words for me. Thank you.
Thank you, Representative. Any further discussion? Seeing none, Mr. Clerk, will you please call the roll?
A roll call vote has been requested and a motion duly made and seconded on agenda item 7, House Bill 5264, an act concerning volunteer fire departments and ambulance companies and the definition of employer under the State Occupational Safety and Health Act. The motion is to JF this to the floor. Senator Kushner.
Senator Kushner votes yes.
Representative Sanchez.
Representative Sanchez votes yes.
Senator Cabrera. Representative Wilson.
Representative Wilson votes yes.
Senator Sampson.
Sampson is no.
Representative Weir.
Rep Weir is no.
Representative Ackert. Representative Belton.
Belton is yes.
Representative Hall. Representative Hughes.
Representative Hughes is a big yes.
Senator Lesser. Representative Yacarino.
Yacarino's no.
Thank you, Mr. Chairman.
Thank you, Mr. Clerk. Votes will be held open. I'd like to motion to JF to the floor, item 8, HB 5265, an act concerning workers' rights. So moved, Representative Wilson.
Rep Hughes seconded.
Representative Hughes seconded. Discussion? Representative Weir.
Okay, thank you, Mr. Chair. We had this concept floated last year, and if I recall, what I'd like to know, we got a few questions. Can you tell me where have we heard, and last time I know this was important to the governor, where have we heard complaints from specific industries? And if we've heard complaints about non-compete agreements from specific industries, can you let me know where we've heard from specific industries of complaining about non-competes?
Representative, we're not on that bill just yet.
I apologize.
No, that's fine.
What number are we on? I heard non-compete.
We're on HB 5265. It's
My apologies. I skipped one down.
no, that's fine.
Wrong page. All right, so we're 5265.
It's item 8 on the agenda.
Thank you. 5265. Thank you. Can you confirm if this is a placeholder bill?
That is correct, Representative.
Thank you.
Thank you, sir. Any further discussion? Senator Sampson.
Thank you, Mr. Chairman. I will just say ditto to my previous comments on the other placeholder bills. I'll be a no.
Thank you, Senator. Any further discussion? Seeing none, Mr. Clerk, will you please call the roll?
A roll call vote has been requested and a motion duly made and seconded on agenda item 8, House Bill 5265, an act concerning workers' rights. The motion is to JF this bill to the floor. Senator Kushner.
Senator Kushner votes yes.
Representative Sanchez.
Representative Sanchez votes yes.
Senator Cabrera. Representative Wilson.
Representative Wilson votes yes.
Senator Sampson.
Sampson votes no.
Representative Weir,
Weir is no.
Representative Ackert, Representative Belton,
Belton votes yes.
Representative Hall, Representative Hughes,
Hughes votes yes.
Senator Lesser, Representative Yakarino. Thank you, Mr. Chairman.
Thank you, Mr. Clerk. Motion to JF to the floor, item 9, HB 5266, an act amending the time to protest benefit changes on an employee's unemployment insurance quarterly statement.
So moved.
So moved, Representative Wilson,
Seconded, Rep. Hughes.
seconded, Representative Hughes. Discussion. Senator Sampson.
Mr. Chairman, are we on item House Bill 5266, an act amending the time to protest benefit charges of an employer unemployment insurance?
Yes, sir.
Yeah, just wanted to make sure. Some of the documents we have are lengthy and confusing. I just want to make sure we're on the same page. So this looks like a relatively straightforward and simple bill that reduces from 60 to 40 the number of days that an employer has to file with the administrator to contest unemployment benefits that are improperly charged due to fraud or error. Can I ask what the reason is for this change?
Senator, give me 1 second. Senator Kushner.
Testimony from the Department of Labor that shortening the time period would benefit everyone in terms of processing such claims, and that now in these times this is done electronically, so it's much easier. So it's really adjusting to the changes that we've made to modernize our system and make it a smoother processing for all involved.
Senator Sampson.
Thank you very much, Madam Chairman. I appreciate that you said that this would benefit everyone. Maybe there was more to that sentence, but the one group of people that it's certain to benefit are people that have gotten unemployment benefits they don't deserve through fraud or error. Can I ask why we want to benefit that group of people?
Senator Kushner.
I don't read it that way, but I will go back and look at that. I don't think that's what.
Senator Sampson.
Thank you, Mr. Chairman. Madam Chairman, the thing about this bill is it's a super simple bill. It says that the employer, which I want to just remind everyone that very often in some of these cases, it could be a municipal employer too. So you're talking about, eventually, costs passed on to taxpayers in every town, Connecticut. But what this bill does effectively is it shortens the time you have as an employer to report unemployment benefits that were awarded fraudulently or through some error. And effectively what you're doing is you're saying to the employer, well, you used to have 60 days to report that. Now you're only going to have 40. It makes no sense to me why we would shorten up that time. I don't know why you wouldn't have forever to report it, or at least some reasonable time frame, a year. You could discover fraud a year from when it happens. And in fact, that's a good question. Can I ask, when does the clock start on the 60 or 40 days?
Senator Kushner.
Just give me a moment.
It's on lines 27 and 28.
I believe it starts from the date the quarterly statement was provided. I mean, that's what it says in the statute.
Senator Sampson, sorry.
Yeah, thank you, Mr. Chairman. Yeah, that's correct. The timeline begins from the moment the statement was provided. It's not even from the point that the fraud or error was discovered. So just imagine how difficult this might be for an administrator, somebody who works for a municipality or for a large company, to discover this error or fraud associated with the unemployment benefit, and that they've got this extremely narrow window of time to not only file it, but they got to discover it before that. So is there any limitation, Madam Chairman, on the size and extent of the fraud? And the reason I'm asking is, does this mean that if somebody could defraud the unemployment compensation fund by a significant amount of money, and as long as it is not discovered and reported within 40 days of the date the statement was provided, that they could get away with it? Is that what happens?
Senator Kushner.
This is for when the employer can protest, not when, whenever fraud is discovered, the state can enforce its regulations around fraud. This is just for the employer to protest such determination by the DOL. So I'm not sure that it applies in the way you're interpreting it.
Senator Sampson.
Thank you, Mr. Chairman. I appreciate that answer. I don't think it's accurate to say whenever, because I'm quite certain there is a statute of limitations for fraud, even for this particular instance of dealing with unemployment. But the issue is not whether or not the state has any recourse to prosecute a criminal for committing fraud. I'm more concerned about whether an employer can recoup damages or money that they have lost as a result. And just because the Department of Labor wants to streamline their operation, they're effectively saying to employers that we're giving you a tiny window to find these problems and get to us. Otherwise, you're out of luck. Go ahead. If I'm wrong with this, Madam Chairman, please jump in there.
Senator Kushner.
I do believe, and we can seek clarification from DOL about this, but I believe that this is about when DOL finds fraud, that the employer has a certain amount of time to object. So the employer has, and I think we can get further clarification from DOL on this. I don't think it's just a matter of them trying to streamline their policies and practices. But I do think that perhaps this is being misunderstood, and we would benefit from meeting with DOL on it, because it's not how I understand it. Certainly, I believe we should move this bill forward, and if we need to, and I'm sure DOL would be happy to sit down and make sure that there's a fuller understanding. And I appreciate that you will likely decide that under those circumstances you have to vote no, but I would encourage my colleagues to move this bill out of committee so we can continue this discussion. Thank you.
Thank you. Senator Sampson.
Thank you, Mr. Chairman. Thank you, Madam Chairman. I certainly didn't attempt to mischaracterize the bill, and I hope that I didn't do that. But let me just say that I understand the bill completely. I don't need any more time to understand what it does. And it's very clear what's happening is that the Department of Labor is going to notify an employer about fraud or error, and they're going to issue that notification to the employer, and then the employer is now going to be limited to 40 days from that point to protest the finding of DOL. And what I'm suggesting is that window is awful small, especially you're talking about a large company. You're asking them to do their due diligence in collecting information and reviewing these cases and understanding what's going on. And I just think that this is an impediment to employers and municipalities. And case in point, there is testimony from the CBIA representing the business and industry folks in the state of Connecticut, making that exact point, and also the advocacy manager for the Connecticut Conference of Municipalities makes the exact same point. So based on my commentary earlier, that this could be damaging both to businesses. Well, obviously, costs passed on to businesses are an impediment to all of us. That's why we pay so much for things. That's why I can't even cover the bottom of my grocery cart for $100 anymore, among other things that the state government has done. And certainly anything that becomes a cost to municipalities becomes a tax to the residents. So that's why I have concerns about this. And again, Madam Chairman, I appreciate the desire to look deeper into these bills as they move forward. But I'm reading the plain words on the paper. I can see what is intended, and I disagree with it. I'll be voting no. Thank you.
Thank you, Senator. Any further discussion? Representative Weir.
Thank you, Mr. Chair. And listening to that, I read the testimony from we had 3 pieces of testimony submitted. Again, as my colleague pointed out, 2 in opposition, Connecticut Business and Industry Association and Connecticut Conference of Municipalities. And in favor was the Department of Labor. And obviously the people in opposition were saying we already have a tight window to within which to act. And so we don't want this window closing anymore. Department of Labor testified that they too have a tight window to do their reporting by the end of each quarter. And so what I'm seeing is a suggestion that in order for DOL to comply, it would make it easier on them to close the window a little bit for the employer in which to make their reporting easier. And I think there may be something in here we can talk about down the road, and that's perhaps opening up the window for DOL without closing the window for, maybe we expand. Obviously, we're not going to solve that today. I'll be a no today with this, but if we're looking to solve the issue without penalizing one or the other, maybe we can talk about opening up that window for Department of Labor, give them another few days, instead of the end of the quarter, maybe they have 60 days. It says in the commissioner's testimony that they have till the end of the quarter. And it seems to me if this coming quarter is March 31st and they found out about it on March 21st, it seems hard to believe that they would only have 9 days, or if they found out about it on March 30th, that they'd have to close their books the next day. So I'd like to maybe talk about how to put a number of days rather than an end date, drop dead end date. Again, happy and open to learning more. So for today, I'll be a no, looking forward to further discussion. Thank you.
Thank you, Representative. Any further discussion? Seeing none, Mr. Clerk.
Representative Sanchez?
I apologize. Senator Kushner.
Yeah, I just want to say that it's my understanding I've been told that there's been a misunderstanding about this piece of legislation, and that the Department of Labor is happy to clarify that for folks, including the CBIA, and that I think that we need to move this bill forward, and we may find that we can come to some agreement around it, including agreement from the business community. Thank you.
Thank you, Senator. I apologize for not seeing you there. Any further discussion? Seeing none, Mr. Clerk, please call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 9, House Bill 5266, an act amending the time to protest benefit charges on an employer's unemployment insurance quarterly statement. The motion is to JF this bill to the floor. Senator Kushner.
Senator Kushner votes yes.
Representative Sanchez.
Representative Sanchez votes yes.
Senator Cabrera. Representative Wilson.
Representative Wilson votes yes.
Senator Sampson.
Sampson is no.
Representative Weir.
Rep Weir is no.
Representative Ackert. Representative Belton.
Belton votes yes.
Representative Hall. Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Yacarino. Thank you, Mr. Chairman.
Thank you, Mr. Clerk. Votes will remain open. Moving on to the next item, motion to JF to the floor, item 10, HB 5267, an act making changes to and repealing obsolete provisions of statutes relevant to the Labor Department.
So moved.
Seconded, Rep. Hughes.
Wilson, seconded by Representative Hughes. This bill makes various unrelated changes to labor statutes As an example of which explicitly authorizes the labor commissioner to enter into contracts for all programs, activities, services, and grants under DOL's jurisdiction, and specifies the powers and duties listed in the statute. The commissioner's powers, duties are in addition to, do not limit any other powers and duties conferred to the commissioner to other statutes. Any further discussion on the item? Right, Senator Sampson.
Thank you, Mr. Chairman. I appreciate that description, and I know this has been put forward as somewhat of a, more of a non-significant policy, more technical kind of change kind of bill, although it does make some policy changes. I guess the only real concerns I have looking at this is in section 1, what you just described, which has to do with giving the labor commissioner this authority. I'm just wondering, I mean, how significantly we're expanding the authority of the labor commissioner to act autonomously and independently of the legislature? I mean, are there things being granted in this statute which would normally be something that we would have to debate and vote on? And are we losing oversight of our own state government by transferring that responsibility to the commissioner, and therefore undermining our constituents' ability to have representation in that decision making?
Senator Kushner.
I believe that this is as stated, a technical change that will make sure that the language of the statute conforms with what we already require of the Department of Labor, which is to enter into these contracts. I don't think it is extending any additional powers. It is not intended to.
Senator Sampson.
Thank you, Mr. Chairman. And so, Madam Chairman, for legislative intent, which we were discussing about earlier, it's your position that this does not, this bill does not expand the authority of the labor commissioner to enter into agreements or contracts that would have been prohibited without legislative oversight?
Senator Kushner.
As I stated, and for legislative intent, that this language is to clean up the statute to make sure that our Department of Labor commissioner is able to make the contracts that she's already required to do under the way we operate in the DOL, and not to expand her powers beyond what we expect now or have now in operation for the Department of Labor.
Senator Sampson.
Thank you, Mr. Chairman. Thank you, Madam Chairman.
Any further discussion? Representative Weir.
Thank you. Just a couple points of clarification. Page 2, lines 31 through 36. Talks about the commissioner entering into contractual agreements as may be necessary for all programs, activities, services, and grants within the jurisdiction of the labor, including but not limited to employment and training programs in the state. Can you give me an example of some of what a training program or employment program that the Department of Labor the commissioner may enter into? Just trying to get a context for what we're talking about.
Senator Kushner.
I'm sure there are many, many cases in which the Department of Labor enters into contracts with programs, training programs specifically. The one that comes to my mind is when we passed law in recent years that allowed the Department of Labor to enter into a contract, which we then funded at the legislature to have certain training programs about workers' rights under the law, like specifically for domestic workers. Many domestic workers were not aware of their rights under the law, for instance, to minimum wage, a longstanding right that we've had in the state of Connecticut, a requirement of employers to pay domestic workers the minimum wage. The Department of Labor, as well as the legislature, we found it helpful to use organizations that were in touch with domestic workers to make sure they were aware of their rights. That would be an example of particular particular case of a training program. I do think that one thing that is important to note is that, as happens with our laws from time to time, the Attorney General's office looked at the current statutes and the current way the Department of Labor is operating and advised that it was important to have this technical change in the statute so that we have dotted all of our I's and crossed all of our T's. So I think it was a recommendation that came from the AG's office to do this.
Representative Weir.
Thank you for that answer. I was just curious, was cautioned initially when we said we're doing this already, and then I'm curious why this was new language, but obviously because somebody found, well, not somebody, the Attorney General found, or his office found something wrong with the language. Okay, that solves that question. And then can we talk on page 4, line 93-ish, talking about stop work orders, and it says the Commissioner 96 that Commissioner shall issue not later than 72 hours after making a determination of a violation, a stop work order against the employer requiring the cessation of all business operations of such employer. Through you, Mr. Chair, or Madam Chair, if that violation was to be corrected, is the Commissioner still required to issue that stop work order? Let's just say that the employer corrects the violation within that 72-hour window. Is that stop work order still mandated to occur even if the violation has been corrected?
Thank you, Representative. Senator Kushner.
Again, if you would direct me to the section of the.
Representative, if you could direct her to this section.
Section 4, and I read it as effective from passage. Now, maybe that's existing law. Forgive me if I'm reading that wrong, but section 4, C1.
Hold on one second. 4C1. It'll take me a minute to get there.
I'm being told it may be existing. It is existing language. So I was reading effective from passage, thinking that this is going forward and this is existing.
I suspected it because I hadn't heard about that. Yeah.
Okay.
Are you with that? Yep.
All set. Thank you, Representative. Any further discussion? Seeing none, Mr. Clerk, will you please call the roll?
A roll call vote has been requested and a motion duly made and seconded on agenda item 10, House Bill 5267, an act making changes to and repealing obsolete provisions of statutes relevant to the Labor Department. The motion is to JF this to the floor. Senator Kushner.
Senator Kushner votes yes.
Representative Sanchez.
Representative Sanchez votes yes.
Senator Cabrera. Representative Wilson.
Representative Wilson votes yes.
Senator Sampson.
Sampson votes no.
Representative Weir.
Rep Weir is no.
Representative Ackert. Representative Belton.
Belton's yes.
Representative Hall. Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Yacarino.
Yacarino, no.
Thank you, Mr. Chairman.
Thank you. Votes will be held open. Motion to JF to the floor, item 11, an act concerning the Labor Department.
So moved.
So moved.
Seconded,
Representative
Rep. Hughes.
Wilson, seconded, Representative Hughes. Discussion. Senator Sampson.
Thank you, Mr. Chairman. Is this another quote unquote dummy bill on this agenda?
Yes, sir, it is.
Can you tell me how many total placeholder / dummy bills we've done on this one agenda?
I believe we have a total of 3. Might be 4. This is actually the 4th. Senator.
Thank you, Mr. Chairman. Can I just ask again, is there a specific reason why we need 4 placeholder bills on one agenda when we already have, I don't know how many bills that we've already JF'd out of this committee. I mean, this agenda has, over a dozen bills on it also. So I just don't, I'm trying to understand the reason for why we need all this extra bill titles.
Thank you, Senator. Senator Kushner.
We choose to have that many because that's how many we might need. If we don't need them, then there's no harm. But that is clearly what the chairs thought was appropriate.
Senator Sampson.
All right. Thank you, Madam Chairman. Thank you, Mr. Chairman. I will just register my objection to this type of bill. I don't believe it is suitable or in keeping with the legislative process. Once again, creating a vehicle to ignore public input in the lawmaking process to me is not something we should be up to. So I'll be voting no. Thank you.
Thank you, Senator. Any further discussion? Seeing none, Mr. Clerk, will you please call the roll?
A roll call vote has been requested and a motion duly made and seconded on agenda item 11, House Bill 5268, an act concerning the Labor Department. The motion is to JF this bill to the floor. Senator Kushner.
Senator Kushner votes yes.
Representative Sanchez.
Representative Sanchez votes yes.
Senator Cabrera. Representative Wilson.
Representative Wilson votes yes.
Senator Sampson.
Sampson votes no.
Representative Weir. Representative Ackert. Representative Belton.
Representative Belton votes yes.
Representative Hall. Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Yacarino.
Representative Yacarino, no.
Thank you, Mr. Chairman.
Thank you, Mr. Clerk. Motion to JF to the floor, item 12, an act concerning non-compete agreements.
So
So
moved.
move, Rep. Hughes.
So moved, Rep. Hughes, seconded
Second.
by Representative Wilson. This bill sets limits on using covenant to not to compete provisions in employment contracts. Any further discussion? Representative Weir.
Now that we're on the correct bill, I'd like to, so just, can we talk about some of the, I guess, where are the concerns coming from? I know, like I said, as I started earlier, the governor was interested in this bill last session. We talked about this. What specific industries are we hearing concerns and complaints with, Mr. Chair?
Senator Kushner.
I know last time we had testimony from individuals. The one I recall, I believe it was somebody who did exterminating and opened his own business. And I think it was very compelling testimony because he, in order to be able to move ahead, he had to spend almost a year's wages or more than a year's wages on legal fees. We've also heard about this being employed now, shockingly, in some fast food restaurants.
Representative Weir.
Okay, thank you. And can we talk about, can you let me know what are the thresholds for the non-competes? What type of salary and wages, what workers are covered under this? Mr. Chair, Madam Chair.
Senator Kushner.
I believe it's clear in the bill, but let me come to it. I don't want to get it wrong, but I'm just going by recollection. But I believe, moment, I can look it up.
For a moment.
I know that, what I believe to be the case is for an employee, I believe it's 3 weeks. I mean, 3 times the minimum wage. But if we could ask LCO to confirm that, I believe that's what my recollection is. My copy, unfortunately, is coming up online with in a way that it's very hard to read, as you heard me say throughout this committee meeting, and so it's a little difficult to like go right to that spot. But can we ask LCO to confirm that?
Certainly, Senator Alcio.
So the language she's referring to are in lines 122 to 125. So it's an employee whose hourly wage is less than 3 times the minimum fair wage, or an independent contractor whose hourly wage is less than 5 times the minimum fair wage.
Thank you. And I was able to find it once you gave me the line number, so I appreciate that. That was my recollection, but I hate to go from memory.
Representative Weir.
Just quick math, 3 times minimum wage is roughly $47 an hour, times 40 hours a week, times 52 weeks a year. That's somebody making $97,900. So just a hair under $100,000. So anybody $100,000 and below cannot be subject to a non-compete. Is that correct?
That is correct, Representative.
Okay, thank you. How was that amount determined? How do we pick 3 times the minimum wage and 5 times the minimum wage for an independent contractor?
Senator Kushner.
I believe that was given thought to in terms of the population we're trying to cover, how much their earnings are. Keep in mind that the non-compete is generally used for people who have access to very important proprietary information from an employer. And we also wanted a threshold here that made it very easy to enforce. In terms of the independent contractor being at a higher rate, I don't know if that's your question, but I think that's intended to account for expenses that an independent contractor has that an employee might not have.
And if I may add, it was similar to Washington, and it was the model that we were using, which did 100,000, and then employers, employees, and 250K for individual contractors.
Washington State.
Correct.
Just want to, before I get back into questions, I want to point out that last year, the state of New York, their legislature passed, I don't remember the exact numbers, but they had a proposal that passed both houses, and it went to the governor's desk, and Governor Hochul vetoed it. And her statement was, New York has a highly competitive climate and it's home to many different industries. These companies have legitimate interests that cannot be met with the legislation's one-size-fits-all approach. So I want to caution this body, where we've picked anybody under $97,000, roughly $100,000 a year, regardless of industry, and we've painted them with a broad brush. And I tend to see that up here a lot, where maybe I guess it makes it maybe more clear cut for us, easier for us to draw a line somewhere. But I would be much more interested in knowing which industries. I heard pest control or extermination. I heard some restaurant workers, but I didn't hear a groundswell of people come to give concerns. Doesn't mean that that doesn't exist, but I didn't, of all the testimony we heard, that doesn't stand out to me as some of the largest numbers, the people who are here the loudest. So I want to make sure that New York is a neighboring state, right? They just proposed something like this, and last I checked, all 3 branches of their government were Democrats, similar to here, and And the governor looked at that, at their competitive climate, recognizing that states compete for resources, they compete for labor. You know, states are competitive and people go where business goes, commerce goes, where you know, the business climate is inviting, not maybe where our message is saying, look, it's restrictive here, our regulations are high, energy is expensive, taxes are high, and oh, by the way, we're going to limit you from putting a non-compete agreement on anybody under $100,000 a year because Washington State says so. So I really want to caution us on painting a broad brush. As being an employer at times, we have asked and offered non-compete agreements to certain classes of workers, certain levels, certain job descriptions. Sales comes to mind. People in a sales environment, you're with a customer. It's a relationship-driven business, and there's proprietary information. Obviously, they've recognized the non-solicitation, but going to work for a competitor and then being put in a sales environment, some of that really important information can get out to a coworker. So I want to caution us on putting forth. I think we'd be much better off had we solicited information on which industries, which employees, which levels and classes and industries where employees have these concerns outside of just two, before going and painting this across all industries, top to bottom. I think that this is really restrictive. Maybe how it's, you know, I don't know if that was the intent. I want to go to, bear with me here.
If I may, Representative, Senator Kushner had her hand up, so is that okay? We can come right back to Senator Kushner. Thank you, Representative.
I just want to point out that we did look at what happened in New York, and it's our understanding that the legislation has been redrafted in a way that Governor Hochul would then likely sign. Obviously, we can't speak for her, but I do believe our bill had already taken into account what her objection was. So I think, you know, obviously we can't speak for where New York will land, but we have watched it carefully. And I believe that the fact that New York didn't have an easy enforcement mechanism like salary threshold, that made it more difficult for them. And they are going to reintroduce that bill this year and address that, something we've already done here. That's my understanding. Obviously, we won't know until it's actually done.
Representative Weir, thank you.
Thank you. Okay. So I not to be cute, but I hope, we're not waiting for Governor, or maybe Governor Hochul's watching us to see if we're going to make a sound decision. And if we do, maybe she'll be towed again. Any rate, Section 6, page 7, Section 6, talks about the Attorney General may investigate, intervene, or bring a civil action in the name of the state, seeking injunctive or declaratory relief, damages, and any other relief that may be available under law whenever any employer is or has engaged in a practice or pattern that, and it goes down to different violations of Section 2, Section 3, and it gives tremendous power to the Attorney General, in my observation. When we have disputes between two parties, you obviously have the opportunity for civil court. If there was a labor violation, an employment violation, the employee has the recourse of our Labor Department. Why does this legislation involve the Attorney General, all the force and power of the Attorney General's office on the side of the employee? And we don't, basically bringing all that force down upon an employer. Madam Chair or Mr. Chair.
I believe what we're doing.
Sorry.
I'm sorry. I believe what we're saying here is that we have statutes that, any laws that we have in our state, that we can choose to say that we want the Attorney General to be the enforcer. I do want to point out that in this case, it's not going to the Attorney General in individual cases, but if it, like in the case of an individual employee, but where there's a pattern or a practice by an employer, the AG can step in.
Representative Weir.
Okay, thank you. And that's not something that we want to leave in the hands of the Department of Labor. We feel that this is necessary to bring to the full force of the Attorney General in certain cases. That's the way I'm understanding it. You said if there's a pattern.
Correct. Correct.
And I'm trying to find the section, but it looks like it does not apply to, this does not apply to physicians, homemakers, companions, or home health aides, and broadcast employees. Am I reading that right? I know I made, bear with me here while I try to find this section.
If you want, I can start by telling you that my understanding is there's different statutes that apply to physicians. I know we've taken that up in public health in the past. And in terms of some of this, specifically, these are covered under other statutes that currently exist. I mentioned the physicians, but I think it's true for the other categories you mentioned.
Thank you, Senator. We'll be on a brief hold while Representative Weir is looking through a section. Thank you.
Okay, I think we'll have to come back to that. I'm just going to go through because I do have a question. There's an area that I do not seem to understand here, and this is section 2, page 5, section 2, subsection 10. No covenant not to compete shall be enforceable against a worker unless the following conditions are met. And section 10, or subsection 10, says the covenant not to compete does not require a worker to submit to adjudication in a forum outside of this state or otherwise deprive such worker of the protections or benefits of this section. Can you try to explain that to me? What I think I understand, but I'd like to hear it from people who drafted it.
Again, could you give me that citation again? And in this case, I actually can see the line numbers. They're a little confusing the way they show up, but I do see them if that's helpful.
You want me to reread it?
Or just give me the line numbers if you have them handy.
116 through 118.
And the other reference?
Yeah, section 2, subsection 10.
So I think if an employer can't use as a defense for their non-compete, that they're allowed to do it in another jurisdiction in another state.
Representative Weir.
Thank you. Thank you. So meaning they can't have the resolution occur in another state?
In other words, if another state allows this employer to have a non-compete in their state, the employer can't take this employee and try and enforce a non-compete in another state.
Okay, and I'm reading that, well, I don't know if we can get a legal opinion on that.
You'd like to refer
Yeah.
some of that to some of the language questions to LCO?
Yeah. Yeah.
Okay.
Maybe.
By all means.
In other words, what I'm told in the drafting of this is that it means that they can't put in a non-compete and say this is governed by the laws of Montana, when in fact we have said in our state that you cannot do this under the circumstances outlined in this bill. So we say that we prohibit a non-compete in Connecticut for certain employees, and then the business tries to put into a non-compete that says that this is governed by the laws of another state. That's my understanding of this. I don't know if LCO wants to try and clarify it.
So Senator Kushner is somewhat right, yeah. In some contracts, they do provide that if any disputes arise under the contract, the matter has to be handled in an out-of-state forum, and a lot of times this comes up in arbitration. So this is basically saying that the covenant not to compete can't contain a provision saying that.
I just try to think of the example where you've got maybe a multi-state company. A lot of maybe they're incorporated in another state and they're doing business here. Obviously, our laws apply here, but if I know I've entered into agreements with other companies where other states have been listed as the kind of the law of the land, where the company is incorporated. So you're saying that this would supersede that, and any adjudication would have to occur in Connecticut. Is that some understanding?
Correct.
Thank you. Yeah, I guess it concerns me that we have long-standing, there's legal precedent set on what is a reasonable and what is an unreasonable non-compete, covenant not to compete. And it's almost like we're rewriting case law with this document. I don't see again, I disagree. I have a great concern, as I've stated, with the just broad brushing this across an income level versus giving consideration to the industries and the workers that this is actually affecting. In some cases, I find it confusing, and confusing to a business owner or an employee, neither of whom may be attorneys. And in some, this is almost like this was written by the trial lawyers to keep things confusing. And I mean that with all sincerity, that if it's confusing, the dispute is going to end up in court, and you're going to have litigation costs, heavy litigation costs for both sides if we're not clear. And I got to say, a 10-page document to address a non-compete is concerning to me. Just look at section 5 here. Okay, so it says here, section 5, through you, Mr. Chair, section 5, lines 172 through 178. Any worker aggrieved by a violation of the provisions of section 2 or 3 may bring a civil action in the Superior Court for the judicial district where the violation is alleged to have occurred to recover damages, civil penalties, and such equitable and injunctive relief as the court deems appropriate. Any person who prevails in such civil action may be awarded reasonable costs and attorney's fees to be taxed by the court. So does this mean if the if an employee brought an action against the employer and the employer was deemed to be correct, then the employee would have to pay reasonable costs and attorney's fees to the employer?
One second, let me just. Senator Kushner? Oh, that's all right.
I couldn't tell if Representative Weir was done with this question.
So that is my interpretation of that language. I mean, any person who prevails. That is my interpretation of the language.
Okay, so just,
But I will defer to LCO if I'm,
Yes, it would be whichever party, I guess in layman's terms, wins the case may be awarded attorney's fees by the court.
okay, so if an employee brings a case that, and the employer is deemed to be the winner in court, if the attorney's fees and court costs are $50,000, that could be, the employee could have would be responsible for that, for those reasonable, well, the winner. So I'm saying that, all right, so if the employee wins, then the employer is responsible for paying those reasonable costs and attorney's fees. And if the employer wins, then the employee is responsible for paying.
that is my interpretation. LCO?
Representative Sanchez,
Senator Kushner, my apologies.
that's okay. I do believe that you're correct, Representative Sanchez. That's the way it's written. I'm not sure that's what we intended, so we will take a closer look at it. For now, I would ask that our colleagues vote yes to get this out of committee so that if that needs to be addressed, we would do so through an amendment.
Thank you, Senator. Any further questions? Representative Weir.
Yes, thank you. I think, this, I was looking at this bill as really one-sided against the employer and kind of breaking with existing case law. And here we've put, through this language, we've inadvertently maybe put the employee at a detriment. So, I guess however many paragraphs, like 32 to the employee and 1 to the employer, we'll give them that one. Went through the Attorney General. I got to tell you, not being an attorney, this is confusing to me. This one of the more confusing pieces we've gone through today. I think this is going to open things up to litigation, and when things go to court, they get expensive for all sides. I said, I think I shared my personal experience as an employer of having non-competes and being very using them very judiciously, because on all sides, it's they're difficult to enforce to begin with. They're expensive, and at some point, both sides just say, "Hey, this isn't working out. We're going to move on." The employer does have a duty to protect intellectual property, does have a duty to protect customer base, proprietary information, and I've been told, well, that's covered under the non-solicitation when they're going after a potential customer. But if you're going to a fellow employer, competitor, and giving the secret sauce away, there should be some deterrence to that. And a non-compete doesn't apply in all situations, but I think if used judiciously, we're really hampering an employer's ability to make their own determination whether it's worth to have an employee engaged in one of these. Seems to me that if an employer gave an employee a bogus non-compete, one that is outside of current acceptable case law and reasonable standards, that would be thrown out on its own without the need for this confusing and seemingly one-sided language. We've carved out a few. Actually, I want to, just something's catching my eye here. Line 229, 230, section 7, subsection A. What is NAICS code 339032?
I'd like to turn to LCO for that interpretation.
So this section in general is amending existing law. I believe this is the provision regarding security guards. So this is sunsetting the law as it applies to them, and then it would wrap them into this new law being proposed.
Up until now, we've had a carve out for this one classification of employees, and now we're just looking to spread this to everybody. Under $97,000.
I'm sorry, Representative. Could you repeat the question? I apologize.
So, hearing that this was, that this code, the original law was carved out for one classification of employees. I'm hearing as security guards. Now that is repealed, and we're just spreading the protections or this legislation to all employees under $97,000.
That is correct.
Okay. I'm going to jump back to page 8, line 216 through 218. Did the Attorney General weigh in on this here, subsection F? We're saying the Attorney General shall post on the internet website information on how to file a complaint for specifically this violation. I didn't see testimony from the Attorney General. Mr. Chair.
Thank you, Representative. Senator Kushner?
I believe that the Attorney General is aware of that provision.
Senator Kushner, could you repeat your answer? Thank you.
I said I believe that the Attorney General is aware of this provision within the proposed legislation.
Okay, thank you very much. I'm going to just go back through here. I thought I had a couple other lines that feel like I've overlooked. I'd like to have the courtesy of maybe coming back to them. I'll yield the floor for now and just go back through my notes. Thank you.
Thank you, Representative. Any further discussion? Senator Sampson.
Thank you, Mr. Chairman. This is a topic that we have debated at length in this committee before. And much like the striking workers bill, I think I'll just say a few words about it. And hopefully I never have to, but if we end up a situation where this is before the Senate, I will be more prepared to go through the entire proposal and raise all of my concerns. I'll just say, very quickly from a philosophical standpoint, that this is just another example of the state government, the labor committee, the majority in this position, once again, interfering in the freedom of the people that they represent, who they sworn an oath to protect their freedoms. The fact of the matter is that, you know, both sides of a employment contract or any contract actually are inclined to only sign it if the terms are acceptable and beneficial to them. And the thing about contracts is that, you know, very often the parties don't love every aspect of what's in the agreement, but they've had to come to some sort of negotiation to find something satisfactory. You know, I'm sure every person who's working today wants to be earning more money than what their employer is paying them. But they've agreed to an employment agreement they felt was fair, and the employer did the same, because I'm quite certain they would like to get more productivity out of their employees. And, you know, that's how the world works, you know, but in order for the world to work in this way, those contracts, whether they're employment agreements or housing agreements or purchase agreements, they have got to be voluntary, and they have got to be freely agreed upon. And, you know, when the state decides that they're going to impose restrictions on what can be in contracts, you are not just limiting one side of the equation. I go back to the whole argument about how this committee is focused 100% of the time on helping labor versus employers. It's like every bill on the entire agenda. It's never even-handed. It's never even attempts to be good policy. It is just, how can we find a way to benefit labor at the expense of employers? And it's super frustrating. I can't even tell you. I don't want to benefit anybody at all. I want there to be good public policy. And good public policy in the nature of economic policy, which is what we're affecting here, is freedom and capitalism. That's what good economic policy is. And, you know, what's so funny is that in America, you say these words, and there's a whole portion of the population that somehow takes offense to that. You are all very, very fortunate to live in this great country. Everyone listening, we are all super fortunate. We could have been, you know, born, raised anywhere. People are crashing our border to get here because America has so much opportunity, and because we are so fortunate to have the quality of life that we have. And that quality of life is 100% attributable to freedom and free market capitalism. That's where it came from. It came from the fact that people wanted to advance themselves. That's right, their own self-interest, by creating goods, services, inventing new things, using ingenuity, working hard. Everything that we have built as an American culture and society has led to this. And that is all at its core nothing more than the freedom to engage in commerce. I will also point out that our system is the only moral system that there is. Every other system is immoral. And the reason why freedom and capitalism is moral is because it doesn't apply any force. The parties that are involved in the transaction are doing it for their own benefit. They're doing it because they want to. Might not be perfect agreement, might not be everything that they want, but they're doing it for their own benefit. Otherwise, they wouldn't do it. Every other system applies force. Every other system applies force. And when I say every other system, I can include in that category systems that have destroyed many civilizations, countries, and cultures that have gone before. And I could also include the Labor Committee, because the bills that we're seeing on our agenda apply force. You know what happens when you start to put restrictions on the ability for people to freely negotiate and come up with employment terms or any contractual terms to make a purchase or a labor agreement or some sort of contractual agreement to have work done on a temporary basis, you name it, any type of contract. When the state gets involved and says, we're not going to allow certain types of agreements to exist, it's a very simple answer to the question. Those agreements don't exist. That's the answer to the question. And what happens when those agreements don't exist? Whatever was going to happen doesn't happen. So certain things are not produced. Certain jobs no longer exist. Certain things are no longer invented. That's what happens. So in short, what's happening is you're limiting the amount of actual production that occurs in our society when you interfere with private contracts and limit the scope of them. And when you limit the amount of wealth that is produced in a society, that does not help the poor, because the lowest people in a income situation in any society benefit from the society's overall wealth. That is why in America, the poorest people are better off than they are in other parts of the world. People generally have a roof over their head. They have a cell phone. They probably own a car. So the fact of the matter is, these policies are crushing the opportunity for people to engage in commerce. Not to mention the fact that when they are heavy-handed and clearly benefit one side or one party to what were formerly freely negotiated contracts, they're extremely immoral. They're unfair. Not the first immoral and unfair piece of legislation we've discussed today. I'm going to just go through some of the things that this bill does, but we should all be asking ourselves, what if somebody wants these terms? What if somebody actually wants them? I brought up the other day, I said, oh, it's great that we're, giving people paid sick days, but what if people don't want paid sick days? What if they would much rather their employer was not forced to give them paid sick days, and instead they could have had the money that it cost the employer to provide the paid sick days, that they would have been able to negotiate for? The act of creating a law mandating the paid sick days prevents that from happening. And this particular non-compete bill that's before us is going to prevent things from happening, because employers are not going to be able to do things that they were able to offer before because the law says no. And employees, or the worker in this case, I wouldn't even call them an employer, because if they're in a non-compete agreement, chances are they are effectively acting as a contractor in many respects. They are voluntarily engaging in an agreement, but this will say, no, you can't do the agreement that you wanted to do before. For example, this agreement starts by saying that covenants not to compete can no longer exist unless they meet certain qualifications. The first one is that you can't have one that lasts more than a year. So suppose you are hiring someone for an industry where there are trade secrets involved, and you want to make sure that those trade secrets, which are absolutely core to the success and future success of that business, are maintained. How are you supposed to protect that now? How are you supposed to do that? And how are you supposed to even hire the person who wants to have the responsibility of protecting that and is willing to be compensated for it? How are you supposed to protect your business? Suppose you're an insurance company, or insurance agent rather. Maybe like somebody who has a small business insurance agency and they have 1,000 clients, and they hire someone who's fresh and new, and they make an agreement with them that they're going to give them their start in the business, but they're making a mutually beneficial agreement that that person is going to learn the skills of the trade, and they're going to be able to grow their income along the way. But it's understood that the clients belong to the company because the company is investing in that employee. How can they engage in an agreement now that actually works for them? Because if you limit this to 1 year, you effectively are limiting the employer side of that so that they can't enforce their part of the agreement. They could still offer all of the benefits to that employee, but the employee does not have to honor anything that they might have had to promise the employer. And effectively, what's going to happen is not that non-compete agreement is going to be thrown out. The job's just not going to exist. That's what's actually going to happen. And if I'm, somebody who's got an entrepreneurial spirit and I'm trying to determine my next move in the business world, I'm going to stay out of businesses that are impacted by state laws. And that's unfortunate because you're limiting the ability of consumers to have access to goods and services because you've basically ruined those industries with the impositions passed as legislation. I'm just like so curious about where these things come from. Like in line 81, it says the covenant not to compete is necessary to protect the legitimate business interests of the employer, and with such legitimate business interests could not be reasonably protected by less restrictive means. The fact of the matter is, by putting these types of terms into this legislation, you're making it clear that someday the only way to determine whether or not this is a legitimate business interest or what might be a less restrictive means is going to have to be determined by a court. The mere use of this language is basically going to discourage anyone from wanting to offer an agreement in a case where this might be tested. Even if they're confident that they're doing the right thing, the fact of the matter is it's not clear. It's not clear enough that they would be protected in those cases. In line 86, it says the covenant cannot be more restrictive than necessary to protect a legitimate business interest. Again, according to who? According to who would it be more restrictive than necessary? Section 4 deals with exempt employees. Mr. Chairman, can you tell me what exempt employees are?
Thanks. Line 90, Senator. Thank you.
Representative Sanchez.
Senator Kushner.
I believe that reference is a reference to the exempt employee definition that's under the Fair Labor Standards Act.
Could you repeat your answer, Senator Kushner? Couldn't hear you.
I'm sorry. That reference is to exempt employees under the Fair Labor Standards Act.
Senator Sampson.
Thank you, Mr. Chairman. Thank you, Madam Chairman. So I'm reading the language in the bill, and under definitions on lines 36 and 37, it says it refers to section 31-58. And you may be very correct, but I'm reading section 31-58, and there's a lot here, which it's one of those things about the way our laws are written is sometimes you have to chase down one statute to find another statute to find another statute. But I'm not reading in here an example of what might be an exempt employee. Maybe you can provide me an example.
I don't think there's a precise example of a job classification. The Fair Labor Standards Act is something that provides definitions such as the person works entirely on their own without supervision, or sometimes it could be an employee that has to exercise a great deal of independent judgment. So there are several criteria under the Fair Labor Standards Act to classify someone as exempt. And when you do classify someone exempt, they are not eligible for overtime that they would otherwise be eligible for if they're a non-exempt employee. But there are lots of case law about how the Fair Labor Standards Act has been applied to various employment categories. It is not specifically a title that's given to someone, but it is the actual work that they do that would determine whether they are exempt or non-exempt.
Thank you, Senator Sampson.
Thank you, Mr. Chairman, and thank you, Madam Chairman, for that very detailed answer that still doesn't give me any insight into what might be an exempt employee or why. I understand that there's laws that govern what classifications or categorizations might lead to someone becoming exempt, but I don't know what those are. And that's what my question is. It's not that we do have a policy to determine it, but I'm curious who could be an exempt employee? Even one example might satisfy my curiosity.
If you're waiting for me, I think I answered the question to my best ability. There's a definition under federal law for the Fair Labor Standards Act as to what an exempt employee, what constitutes an exempt employee. I gave you some of those criteria. Certainly, the one that is most frequently used is someone who exercises independent judgment on a regular basis in their job. But I don't know what else to tell you. It's something you can do your own research on. And there has been case law on it. There have been applications on this. But, you know, it's a pretty standard classification employers use all the time to determine whether or not they're paying overtime or required to pay overtime under a federal law. And if they make a mistake, then a person, you know, if a person feels that they've been misclassified, they can go through the normal processes to correct that. But it is, most employers are pretty familiar with what is considered an exempt employee versus a non-exempt employee.
Mr. Chairman?
Yeah,
If I may, one example could just be people who are paid on a salary. It's usually people who are more in the professional role, so they don't get overtime and hourly pay. They're just paid flat salary. Usually, like I say, often people in a professional role, like it could be like an attorney or some other professional role, like an accountant or something like that.
That is true, but I do want to caution because someone can be misclassified as exempt. So it is not the reason why I haven't been able to say it's always an attorney, because an attorney might be hired where they require a law degree, but the person is in their job doing very routine work where they have no ability to exercise independent judgment. In that case, it could be misclassified. And so it is not, there are not specific class names of positions that are cited in the law, as I recall. And in fact, just paying someone on a salary basis versus on an hourly basis is not enough to classify a person as exempt. So again, it goes to the work that's actually being done by the person. And I think one of the main criteria is that they have to exercise independent judgment on a very regular basis in doing their work. And you know, I had to testify on this many years ago. It made a big impression on me, and I am very much aware that there have been misclassifications of employees in the past by employers.
thank you, Senator Sampson.
Thank you, Mr. Chairman. Thank you, Madam Chairman, for your comments, and thank you to the nonpartisan staff for that enlightening answer as well. And I had it in my mind that this referred to salaried employees to begin with, but I do respect the chairman's caveats. So thank you for that. The section goes on with more restrictions on what determines whether or not the agreement could be enforceable or not. It's remarkable too. I mean, you know, the requirement on line 99 to put into the agreement the actual text, not to compete not all covenants not to compete are enforceable is a rather interesting. I mean, should that may be true of every contract. Not every lease contract is enforceable. Should we ask, people drafting leases as tenants and landlords to put that in their contract too? I mean, it's quite clear that this particular policy is designed as a protection for workers. And I don't disagree with the idea that we should be protecting workers, but we're talking about very specific situations where these things come up that there's a legitimate purpose for. Now, I know we've heard some testimony, and I know we've had the chairman describe certain circumstances where certain folks in low-paying jobs were asked to sign non-competes, and they didn't, in some cases maybe, didn't even understand what they were signing and so forth. I get all that, and I'm certainly sympathetic to anyone who's being put in a difficult position like that. But simultaneous with the idea that you're protecting a certain group of uninformed or workers that could be taken advantage of, you're also preventing both employers and employers from engaging in a voluntary contract that might be beneficial to both of them. That's my objection to this. Freedom to me is the best policy. The idea that people should be able to make this up for themselves and decide whether they want to enter into the agreement. That should be the best solution. We are so hot on protecting people these days that we're making people so that they don't even contemplate that they should have to think before they enter an agreement. And I think that's the reason why we have so many other bad contracts that exist in the world, like your cable service or your cell phone service, or when you go on to sign up for a social media account and they make you sign something that's thousands of pages of fine print, and you've just got to do it because no one's going to read that. I mean, we live in that world because we are not teaching our citizens to be free, independent thinking individuals, and that concerns me. So anyway, like I said, I didn't want to go too deeply into this. There is something in section 2 that has to do with the relationship was not terminated by the worker for good cause attributable to the employer or contractor. I'm wondering if the good chairman can explain what that means.
I'm sorry, can you repeat the section, Senator Sampson? I apologize.
It's in section 2. It's in my notes, so I don't know exactly what line it's on.
Okay.
I'm told it's 114, 115. Oh yeah, the employment or contract relationship was not terminated by the worker for good cause attributable to the employer or contractor. I'm very curious about the way that the legislative intent might go on this one.
I'm searching for that in my notes, but I believe a case of good cause could be like sexual harassment case. But it would help if you had the line number or somebody else there does. Or maybe LCO would want to weigh in because I'm not finding it right easily.
It's Senator Kushner, page 5.
Do you have the line number?
It is 114 through 115.
I believe that would be a case of where the employment relationship was terminated because of I think that's one example that where it was not terminated for good cause attributable to the employer. It could be a case of sexual harassment.
Senator Sampson.
Madam Chairman, are you telling me that that's all that this means? That if an employee was...
No, I think you asked one example.
Okay, and can I just ask through you, Mr. Chairman, who determines whether something's good cause?
Senator Kushner?
I would think that in this case, as in other cases, it would be determined by a court or any agency that was lawfully interpreting the statute that was, but I believe we're talking about a court would determine that. So in other words, if an employee left an employer's employ because they were being sexual harassed, they couldn't then enforce their non-compete if it was an employee who otherwise the employer could have a non-compete. In other words, they're not covered by the exclusions that we've laid out here, the 3 times the minimum wage for an employee and 5 times the minimum wage for an independent contractor. If they were to leave employment because they were sexually harassed and the employer feels that they didn't sexually harass them, I suppose there could be an effort by the employer to enforce their non-compete through court action.
Senator Sampson?
Thank you, Mr. Chairman, and thank you, Madam Chairman, for the answer. I'll tell you, I mean, this is a very important couple of sentences in this document. And I appreciate the desire to include the potential circumstances of sexual harassment as a part of it. But I think this goes way beyond any similar situation like that. I mean, the fact of the matter is, presumably, if folks have a non-compete agreement, that means that they have an employment contract. And chances are, if it's got a non-compete agreement and it has it's a written employment contract, and presumably if it's a written employment contract, it has terms, and it probably has terms regarding separation and what the rights of the parties are. I would guess that the good cause would mean a failure to uphold part of the contract. Would you disagree with that, or are you going to stick to it's got to be some other outside event?
I don't disagree that if there was a contract with an employer, that an individual who is not covered under, the other reasons that it would be unenforceable. But if there was an agreement with an employer and they had a non-compete, and there were other obligations by that employer that were written into a contract, and the contract was, and the employer didn't live up to those contractual obligations, that person could determine that there was no good faith. And if the employer go to another place of employment that was not allowed under the non-compete. However, if the employer felt that they did not violate that contract, they would have the same option to go into court and prove to a court of law that the employee was bound by the non-compete that they had signed.
Senator Sampson?
Thank you, Madam Chairman. Is this provision that is in section 2 that I'm referring to, subsection 9, lines 114 and 115 regarding the good cause, is that linked to the language in section 4, starting on line 165, subsection C, saying the party seeking to enforce a covenant not to compete or exclusivity agreement against the worker shall have the burden of proof in any enforcement proceeding for such covenant not to compete or exclusivity agreement?
You'll have to give me a minute to look into that. I'm not sure I understand the question. Can you restate it?
Senator Sampson.
Thank you, Madam Chairman. Don't worry about it. I'm looking at this language that's in section 4, and it's quite clear to me. It says that the exclusivity agreement says that the statute here would read that the employer would have to have the burden of proof. In other words, they got to prove it. And I'm wondering why this whole bill is written this way. I mean, both parties are signing the agreement. It's not like the employee's not getting anything. The employee is being compensated. You know, that's why this is a contract. And when contracts by their very definition, when they're signed by both parties, they're mutually agreed to contracts. No one side of that contract is getting an advantage over the other. That's the reason why they both sign it. Now, people can complain about the terms of the contract and they can say, well, they got the better of me in that contract. Well, that may be true. But if you sign it, I don't care if you're the employer or the employee in this case, you have agreed to the terms, which means you're accepting the idea that you and the other party both got what you wanted. Otherwise you wouldn't have signed it, right? But this whole bill is not written respecting that. This whole bill is written that the employee gets every potential benefit to avoid the non-compete agreement that they signed already, using their own hand and their own free will. This sounds a lot like the bill we have in housing about the expiration date of leases. People sign a contract knowing what it is, and this is not the terms of use for Facebook. This is an employment agreement that probably is significantly negotiated by both parties, and probably in an industry that it's customary, like someone who does a lot of sales and has to work with a book of business that's owned by an employer. That's where these agreements occur. And what I'm trying to make sure is that these businesses do not disappear, and therefore the jobs and opportunities that come with them don't disappear either. And that's what I fear for this bill. The language here is very clear that it says that if an employee can invoke any number of things on this list and say, yeah, they didn't fire me for good cause, so I don't feel like I have to live up to the agreement. And now the burden of proof is on the side of the employer. And I don't know why it would be that way. I think it should be done more fairly. I also see, you know, we talked a little bit about the basic building blocks of this bill, which is that in order for a non-compete agreement to be enforceable, currently, under the policy today, which is the minimum wage in Connecticut, that is the determining factor, you've got to earn at least $97,905.60. Is it the understanding of the chairs that anyone that makes less than $97,905.60 is not smart enough to enter into a contract with a non-compete agreement? Do you, Mr. Chairman?
Could you repeat the question, Senator?
Well, I mean, the bill has a limitation. It says a non-compete agreement is only valid if the worker is earning $97,905.60 or more annually, which means that any worker making less than that amount, $95,000, for example, that they are they cannot have a non-compete agreement. So effectively, if you want to enforce a non-compete agreement as an employer, you've got to pay someone $97,000 and change. It's really $98,000, and that's one side of it. But the other side is it the belief of this committee that you're just incapable of engaging in that in a contract that has a non-compete agreement? Because you're not capable or smart enough to protect yourself. unless you make that amount. Is that what we're saying here?
I don't believe that we're presuming that folks are incapable. No.
I appreciate the answer, except what is the other logical explanation for setting this dollar amount for who a law should apply to? And why would we ever apply a dollar amount to who laws apply to?
It was mentioned earlier, we used the Washington State model, which was essentially at $100,000 and $250,000 for individual contractors. So essentially the model that we were basing this off of.
So you're suggesting that we're copying another state's policy, but why?
Similar, just addressing some of the concerns that we have heard about some of these non-compete agreements needing to be in place to protect the employees in these circumstances, and we felt that that number was appropriate at 3 times the minimum wage.
So I'm going to ask the question again. So the committee feels that it's appropriate to protect people that earn $97,905.59, but not people that earn $97,905.60?
Senator Kushner.
I think we used 3 times the minimum wage because it was a bright line we could establish. We could have gone to $100,000 like the chairman said about the state of Washington, but we chose to tie it to the minimum wage. And that means that as wages go up, it will too be properly indexed so we don't get into the problem where 10 years from now, it doesn't have any relevance to inflation or the way the CPI has operated. So I think it just made more sense to the committee to draft it in a way where we're tying it to the minimum wage than using a flat dollar amount like they did in Washington.
Oh, sorry, Senator Sampson.
Thank you, Mr. Chairman. Thank you, Madam Chairman. I'm not trying to drag this hearing out at all, or this meeting out. I honest to God, I'm not. I'm like, this is the last thing I want to ask you, but I want a legitimate answer. Not that's what another state did, or we thought that this was a good number. I want to know. I want to know exactly why people that earn one amount of money are going to be protected, quote unquote, from non-compete agreements, when in fact the non-compete agreement could benefit them. They might gain valuable employment and experience in a job. I don't consider that protection. But why would one group of people be able to get the protection and another person not, based on some bright line threshold, which you made very clear a moment ago, Madam Chairman, is completely arbitrary. We could have used 100,000. Okay, so an arbitrary figure determines whether or not you deserve protections under our laws. Is that what we're suggesting? Through you, Mr. Chairman?
Senator Kushner.
I would say that's a gross misinterpretation or misrepresentation of what I've said. I have never said that. What I have said is that we want to establish a bright line that will be enforceable, that will also move as conditions change in our economy. We chose to protect workers that we believed at that rate of pay should be protected from non-competes, because we think non-compete agreements are very restrictive on the employee and should not be used in those cases. And I think we've heard testimony about it, and we not only wanted to extend that protection, but we did it in a way where we believed over the years to come it would be appropriate.
Senator Sampson.
Well, thank you, Mr. Chairman. And thank you, Madam Chairman, for giving me some actual meat on the bones to the answer to the question I asked, which is the reason why. And what I've got from you is that you believe that covenants not to compete are restrictive on employees. And that's clear from your proposal that that's what you believe. And I certainly respect your right to have that view, except for the fact that you're discounting you know, decades, maybe hundreds of years of common law understanding of contracts, and that contracts exist for the mutual benefit of the parties. Do you not see any situation where someone who isn't considered the employee or the worker could benefit from a non-compete agreement?
Senator Kushner.
I think that we do see circumstances where an employee is compensated in such a way that they are getting some benefit from the employer such that it legitimizes the non-compete. I think what we're saying here is, and I do think for decades and decades, non-competes were used for highly paid, highly compensated employees that had access to confidential proprietary information from an employer. And unfortunately, what we've seen in recent years that has been shocking to me is that employers have used non-compete agreements in situations that are totally unwarranted. And that has caused employees who are not making a lot of money to have to spend thousands and thousands of dollars to fight a non-compete in court. And we don't think they should have to do that anymore. We heard from a person last year that spent a year's wages fighting against a non-compete. And I don't think that should have ever happened. I don't think they got something out of that relationship. I think they were forced to sign a non-compete because they had very few choices of where they could work. And employment was hard to find at the time. And, I don't think that the situations that you so often talk about where every employee is every person is absolutely free to choose whether to work or not to work. It really doesn't take into account the day-to-day circumstances that most workers find themselves in. So I think we came to this conclusion based on what we saw as a problem we were trying to solve. And I think, you don't agree with that, and that is certainly your prerogative, and you make that clear on many of the bills that we propose. We have a disagreement. But I respect your right to disagree, and I assume you respect mine as well.
Senator Sampson.
Thank you, Mr. Chairman. Thank you, Madam Chairman. I appreciate that insight, and I appreciate our mutual respect to agree or disagree. And I certainly feel that completely. And I'd like to point it out very often that we manage to disagree very politely in this committee. The thing that I'd like to just make clear is what we're disagreeing about. You've characterized this bill as protecting employees, and I'm adamantly saying you're not protecting anyone. You're restricting the freedom of all people. That's all this bill does, is it restricts freedom. It doesn't protect anyone. Now, there are certainly people that may have been taken advantage of by an employer by coaxing someone into sign an agreement that did not benefit them, but they did that of their own free will. And we have court mechanisms to deal with that. Here, you are not only preventing and possibly protecting that person in that case, but you are also denying the right of every other person going forward that might fit these circumstances to engage in something they want to do willfully and freely. And that's what I cannot abide. We're not supposed to do that. Our job is not to tell other people how to live. Okay? Our job is not to get in between two people who fully, with their eyes wide open, understand what the circumstances are in a contract and want to sign it. And yet that's what this bill does. And the choice of this dollar amount of $97,905.60 as a bright line is a completely arbitrary figure, and it doesn't indicate anything. Because I can tell you there are people right now that would be more than happy to take the terms of working for, I'll use the example that I know, which is as an insurance agent, which I worked as for many, many years. I understood that I was being compensated to grow not only my future prosperity and wealth, I was also growing the business owner's future security and wealth also. And we made an agreement. And I certainly, at the time that I started, never made anywhere near this amount, even adjusted for time and inflation. And I was more than happy to do it. And I think that's what gave me a lot of the skills that I possess today to be able to work and flourish in our economy. And this denies that of people. And it's going to prevent those jobs from even existing and people from having the same opportunities that I have had. That's why I'm kind of passionate about this, Madam Chairman, because I just know that there are people out there, and it doesn't have to be $97,000 is a lot of money. It's a real lot of money. I would say, it wouldn't be uncommon to see people signing a non-compete agreement to work in a small independent insurance office for as little as $30,000 or $40,000, and they'd be getting a tremendous benefit by doing it. Because they would be establishing a career that has a future to it, and they would have a mutually beneficial arrangement with the business owner. And this is going to deny all that from even existing. And that is such an unbelievable shame. And it is also going to have a negative impact on the prosperity of our state and the people that reside in it. And I guess I'll leave my comments there since I feel that was a good way to wrap it up. So I'll be voting no on this, Madam Chairman, and I'll tell you, I'm going to be doing my homework on this one. Again, this is another bill where I know that the governor has taken a special interest in this legislation in the past before too. I know he has raised concerns about the good cause language that we talked about earlier, because it's I would say nefarious. And I hope that even if this bill does become law, that at least that part goes away. I'll be a no today. Thank you.
Thank you, Senator. Any further discussion? Seeing none, Mr. Clerk, will you please call the roll?
A roll call vote has been requested and a motion duly made and seconded on agenda item 12, House Bill 5269, an act concerning non-compete agreements. The motion is to JF this bill to the floor. Senator Kushner,
Senator Kushner votes yes.
Representative Sanchez,
Representative Sanchez votes yes.
Senator Cabrera, Representative Wilson,
Representative Wilson votes yes.
Senator Sampson,
Sampson is no.
Representative Weir,
Rep. Weirs, no.
Representative Ackert, Representative Belton, Representative Hall, Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Yakarino.
Representative Yakarino votes no.
Thank you, Mr. Chairman.
Thank you. Votes will be held open. Motion to JF to the floor, item 13, an act increasing the threshold amount for felony unemployment compensation fraud.
So moved.
Seconded, Rep.
By
Hughes.
Representative Wilson, seconded by Representative Hughes. This bill increases from 500 to 2,000 the financial threshold that determines whether unemployment compensation fraud is a Class A misdemeanor or a Class D felony. Any discussion? Discussion.
Representative,
Oh, Senator Kushner.
I just a brief piece of information that was asked during the public hearing. I asked what year the threshold was established. Since the time I asked that in the public hearing, I've been told that it was established in 1978. So 46 years ago is the time in which was when this threshold was established. So I think that gives us some clarity, and it does go to the issue of needing to be updated. Thank you.
Thank you, Senator. Any further discussion? Representative Weir.
Just have a few brief comments, and we saw this bill last year, or a concept very similar to it from my recollection. And I want to make sure that the sentiment, that we are recognizing that fraud is fraud. I recognize that numbers have changed. This could be related to inflation perhaps, but I want to point out that, I don't think we want to be looking the other way by changing statutes, giving people the message that that crime isn't serious, that we are down or minimizing the impact of somebody willfully committing fraud. Fraud is a willful, deliberate, knowing act. I don't think somebody commits fraud by accident. It's not generally, it's willful and intentional. And I'm concerned that we're sending, while I recognize some of the implications of being found guilty of fraud, we are sending a message that we will downplay it, that will just lower the amount of the, we're going to raise the amount and the threshold necessary to have committed a felony. And given the state of our current state of crime, crime is on the rise. We've been so lenient across the board. I'm concerned with sending the message that we're going to just add another category where we're going to be more lenient. I'll be a no on this today. Thank you.
Thank you, Representative Weir. Any further? Senator Sampson.
Thank you, Mr. Chairman. I don't really have anything to add. I think Representative Weir kind of covered this bill. I just want to put a finer point on it and just say that the message that this bill sends is that a little fraud is okay. That's what the bill says. And that's an absurdity. A little fraud is no better than a lot of fraud, and we shouldn't be encouraging it. Effectively, this basically says that we're going to reduce the penalty for someone who commits, actively and knowingly and willfully commits fraud against the unemployment compensation system in the state. For me, I don't see any reason why you would look the other way on that activity, whether they walked away with $500 or $1,000 or $2,000. It's all bad, and it all should be treated the same. And certainly, if you want to have a conversation about making stiffer penalties for higher amounts of fraud, I'm happy to do that. But this bill effectively reduces the penalty for up to $1,999 worth of fraud, and to me, that's unacceptable. A little fraud is not okay. Thank you, Mr. Chairman.
Thank you, Senator Sampson. Okay. Any further discussion? Seeing none, Mr. Clerk, will you please call the roll?
A roll call vote has been requested and a motion duly made and seconded on agenda item 13, House Bill 5270, an act increasing the threshold amount for felony unemployment compensation fraud. The motion is to JF this bill to the floor. Senator Kushner.
Senator Kushner votes yes.
Representative Sanchez.
Representative Sanchez votes yes.
Senator Cabrera. Representative Wilson.
Representative Wilson votes yes.
Senator Sampson.
Sampson is no.
Representative Weir.
Rep. Weir is no.
Representative Ackert. Representative Belton. Representative Hall. Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Giaccarino. Thank you, Mr. Chairman.
Thank you, Mr. Clerk. Votes will be held open. And motion to JF to the floor. Item 14, an act studying the establishment of a full employment trust fund.
So moved.
Seconded, Rep. Hughes.
So moved, Representative Wilson, seconded by Representative Hughes. Discussion. Seeing none, Mr. Clerk, will you please call the roll?
A roll call vote has been requested and a motion duly made and seconded on agenda item 14, House Bill 5385, an act studying the establishment of a full employment trust fund. The motion is to JF this bill to the floor. Senator Kushner.
Senator Kushner votes yes.
Representative Sanchez.
Representative Sanchez votes yes.
Senator Cabrera. Representative Wilson.
Representative Wilson votes yes.
Senator Sampson.
Sampson is no.
Representative Weir.
Rep. Weir is no.
Representative Ackert. Representative Belton. Representative Hall. Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Giaccarino. Thank you, Mr. Chairman.
Thank you, Mr. Clerk. Your votes will be held open. Bear with me for 1 second. Okay. Okay, so we'll move on to announcements. The meeting, I'm sorry. Moving on to announcements, our next public hearing is on Tuesday, March 12th at 10 a.m. in room 2B and via Zoom. And our next committee meeting will be Thursday, March 14th at 12 p.m. in room 1B and via Zoom. And with that, this meeting is recessed for votes and attendance until 7:08. That'll be adjourned. Okay.
Senator Lusser, can you hear me? Senator Lusser, can you hear me?
Hello?
Hello, Senator Lesser. I'm taking votes from Rep. Ackert right now. If you could just give me 30 seconds to finish up with him.
You're good. I'll come back
on mute,
actually.
sorry. Okay. 5265, no, there we go. 5266. No. Okay. 5267. Oh, yeah. Okay. 5268. No. And Representative Weir. 5268, that is placeholder Labor Department. Okay. 5269. No. 5270. No. 5385. Yes. And that's it. Okay. Thank you. Appreciate it. Okay, letting in Senator. Thank you very much. Okay, Senator Lesser, I've got you, and I've got Senator Cabrera in as well. I think we can just go through these at the same time, hopefully.
Hey, how are you?
Hello, Senator.
How are you?
Oh, I can't hear you. Give me 1 second.
Yeah.
What's going on here?
Can you hear me now?
Okay. Now I have audio for some reason.
Okay, good.
So let's turn the volume up a bit more.
Yep, go ahead.
Okay, we're good to go now. So,
Gotcha.
Item 1, Senate Bill 136. Do you want me to read off the titles?
No, it's okay. And Senator Cabrera votes yes.
Okay. Item 2, Senate Bill 219.
Senator Cabrera votes yes.
Item 3, Senate Bill 222.
Senator Cabrera votes yes.
Item 4, Senate Bill 223.
Senator Cabrera votes yes.
Item 5, House Bill 5164.
Senator Cabrera votes yes.
Item 6, House Bill 5165.
Senator Cabrera votes yes.
Item 7, I think it is, yes, House Bill 5264.
Senator Cabrera votes yes.
Item 8, House Bill 5265.
Senator Cabrera votes yes.
Item 9, House Bill 5266.
Senator Cabrera votes yes.
Item 10, House Bill 5267.
Senator Cabrera votes yes.
Item 11, House Bill 5268.
Senator Cabrera votes yes.
Item 12, House Bill 5269.
Senator Cabrera votes yes.
Item 13, House Bill 5270.
Senator Cabrera votes yes.
And the last one, Item 14, House Bill 5385.
Senator Cabrera votes yes.
Thank you, Senator.
Thanks. Appreciate it.
Senator Lesser, are you there? Are you available? Hello, Representative Hall.
How's it going?
All right. Let me just grab your attendance first. Okay. Agenda item 1, Senate Bill 136. Do you want me to read off the titles?
Yes, please.
Senate Bill 136, an act making changes to the Connecticut Retirement Security Program statutes.
Yes.
Okay. And Senator Lesser, if you can hear me at any of these, feel free to vote as well. Item 2, Senate Bill 219, an act concerning working conditions.
Yes.
Item 3, Senate Bill 222, an act concerning changes to the paid family and medical leave statutes.
Yes.
Item 4, Senate Bill 223, an act concerning workers' compensation.
Yes.
Item 5, House Bill 5164, an act concerning unemployment benefits, JFS LCO 2618.
Yes.
Item 6, House Bill 5165, an act expanding Connecticut's family and medical leave benefits to non-certified school employees, JFS LCO 2406.
Yes.
Okay. I'm just going to let Rep. Jacarino in as well because he also has a vote to catch up on.
Sure.
House Bill 5264, an act concerning volunteer fire departments and ambulance companies and the definition of employer under the state occupation.
I'm stuck in traffic.
Okay. That's
Could you
all
hear
right.
me?
Yeah, I can hear you, Representative Yakarino. I'm just going through.
I
votes of-
can't hear you.
Oh, I can hear you.
Cameron, could you hear me?
Yes.
I'm a no on the last two bills.
Okay. Thank
Is it-
you.
Oh, am I all set?
Yes.
Thank you.
Okay. Apologies.
No worries.
I think we're good. 5264, volunteer fire departments and ambulance companies and the definition of employer under state OSHA.
Yes.
5265, an act concerning workers' rights.
Yes.
5266, an act amending the time to protest benefit charges on an employer's unemployment insurance quarterly statement.
Yes.
5267, an act making changes to and repealing obsolete provisions of statutes relevant to the Labor Department.
Yes.
5268, an act concerning the Labor Department.
Yes.
5269, an act concerning non-compete agreements.
Yes.
5270, an act increasing the threshold amount for felony unemployment compensation fraud.
Yes.
And House Bill 5385, an act studying the establishment of a full employment trust fund.
Yes.
Thank you, Representative.
Take care. Have a good night.
You too. Senator Lesser.
Cameron?
Hello, Senator.
Hi. Can I vote,
Sorry.
please?
Sir, certainly. Sorry, it's been crazy.
No, all good. We're all multitasking.
Item 1, Senate Bill 136, an act making changes to the Connecticut Retirement Security Program statutes. JF to floor.
In the affirmative.
Item 2, Senate Bill 219, an act concerning working conditions. JF.
In the affirmative.
Item 3, Senate Bill 222, an act concerning changes to paid family medical leave. JFS to the floor. LCO 2702.
Affirmative.
Item 4, Senate Bill 223, an act concerning workers' compensations. JF.
Affirmative.
Item 5, House Bill 5164, an act concerning unemployment benefits. JFS. LCO 2618.
Affirmative.
Item 6, an act, House Bill 5165, an act expanding Connecticut family and medical leave benefits to non-certified school employees. JFS. LCO 2406.
Affirmative.
Item 7, House Bill 5264, an act concerning volunteer fire departments and ambulance companies and the definition of employer under state occupational safety and health.
Affirmative.
Item 8, House Bill 5265, an act concerning workers' rights. JF.
Affirmative.
Item 9, House Bill 5266, an act amending the time to protest benefit charges on an employer's unemployment insurance quarterly statement. JF.
Affirmative.
House Bill 5267, an act making changes to and repealing obsolete provisions of statutes relevant to the Labor Department. JF.
Affirmative.
House Bill 5268, an act concerning the Labor Department. JF.
Affirmative.
House Bill 5269, an act concerning non-compete agreements.
Affirmative.
House Bill 5270, an act increasing the threshold amount for felony unemployment compensation fraud. JF.
Affirmative.
House Bill 5385, an act studying the establishment of a full employment trust fund. JF.
Affirmative.
Thank you, Senator.
Have a good evening.
You too. Hello, Representative Belton.
Hi.
Hello, Representative. I've got 3 outstanding votes here.
Okay.
Agenda item 12, House Bill 5269, an act concerning non-compete agreements. That's a JF to the floor.
Yes.
Agenda item 13, House Bill 5270, an act increasing the threshold amount for felony unemployment compensation fraud. JF to the floor.
Yes.
And agenda item 14, House Bill 5385, an act studying the establishment of a full employment trust fund. JF to the floor.
Yes.
Great, and that accounts for everything. Thank you very much.
Thank you. Have a good night.
You too.